Well, item number.
Top of the list, item 1.
Kindly pass over to time being. Seniors in late.
Let me hear you.
The matter has been heard in the earlier day also. The only question is that whether limitation act is applicable in case of probate or not. The learned trial court has held that there is no guard to filing a petition.
There is no period of limitation.
Limitation.
There is a period of
This
limitation.
issue has been framed, but there has not been discussed whether the will is genuine or duly executed. For that, the question of limitation has to be decided. After that, the question of whether it was duly executed or not, that comes. In this lecture, initial judgment has, I would like to come in a initial judgment of the Supreme Court. Because the delay, more the delay, the more the suspicion. 2020, on last month, it was decided.
23(9) SCC.
125, last month it was decided. Paragraph 6 and 9.
They reported in 2025 to SCC
Yes,
633.
sir.
I actually have problem in trusting these people looking today. Yeah, I got a lot of typographical mistakes. Let me. No. Yes. Why do you want to show the judgment?
Okay. And regarding the point of limitation, I'd like to submit three judgments. One is coercive and limit.
I have delivered one judgment na, in your case.
Yes. Sulata Polo.
You have it?
I have the copy. Kindly consider this. In that case, I have referred a judgment, Samir Kapoor. That judgment held that Article 137 is applicable to probate petition.
No, my judgment, I think, is in your favor.
On that case, Lordship, the question is arise that whether a delay condemnation petition is required or not. But on that case, we have filed a delay condemnation petition. They are not allowed. Against that, they have prepared a revision petition. Court held that although yes, Article 137 is applicable, but a separate delay condemnation petition is not required, Lordship. But delay has to be explained. That is the
I think
issue
that
on
is
that.
what I held it.
Yes.
Because
But
initially
in this case,
I was
Lordship, delay has
against.
not been explained.
Where is the judgment? My judgment.
Official says it is a continuous, right?
Right to sue accused when it is necessary.
It's right. It is not right to sue. It is right to apply.
It depends on the taxes.
They can apply, Lordship, but whether the petition is barred by limitation or that question has to be decided because there is an issue on that question.
Survey का जो name of the person, is a question. Now, the Indian succession law. Now, the will Indian succession. Now, when a will is sought for probate or for letter of administration,
Yes, sir.
There's a particular format in which you are required to be filed.
Another one more thing. For section 281, a probate petition shall be verified by one of the witnesses.
Attesting witness.
Yeah, attesting witness. But in this case, there is no verification on the attesting side. That has to be decided because there are contradicting judgment of the previous high court. But finally, that has not been settled in any way.
No, one of your arguments was on that day, if I remember correctly,
Regarding the will,
the will only gave this particular person, the propounder, to execute only during the period when he was the beneficiary was a minor.
minor,
Now, once the beneficiary had become major,
major,
it is the beneficiary
who has to apply.
who has the right to apply,
Right. That is
not the person
not the
concerned.
person.
That is what you
That-
said on that
That
day.
has clearly been mentioned in the will.
But tell me one thing. That is why I put that question. In a will, normally you don't say anything on a delay unless the other side comes out and objects.
That then becomes a,
Once he objects,
it becomes a regular.
it becomes a regular suit where the person who is the propounder becomes the plaintiff. Then is it not required to explain why it has been done after such a long time? Means can it be given only on the basis of evidence?
Because we have filed our written statement. And also in the evidence, they have not explained why it was delay has been was a long 19 years delay also.
The main question would be whether that person had a right to apply.
That is my question.
If he doesn't have the right to apply,
Petition is not made.
then the question is no. Then the question is there is no duty upon him for the purpose of propounding the will. And if he doesn't have the duty, if he doesn't have the right to apply, then 137 is not cannot be invoked. The right to apply would be only on that person concerned. Let us see the will. I think that is the best. Now we can go. Record. Record.
Another thing of this, he has could have some impression, perspectives. But nowhere in the will, not mentioned why, because he was an educated person. He can write. All the PWs have admitted that he can write her name,
You're suffering from cancer. Within
but one line has to be incorporated.
that is not. Did you put a question on that?
Yes, I have put that.
Let us see the will.
Will for forum. There it is.
Let me get to the will. petition is not supported by the testimonies. Here, you have, during cross-examination, you asked him why he has filed after 18 years. He gives a reply
Stated that, he was
that this was
But-
filed after 18 years from the death of my mother because the beneficiary was a student at the time and I was facing financial trouble. At the time of the registration of the will, so and so, and so and so, and so and so. And I could see another thing. There was an amendment allowed. Seventh thing, being to allow a third party to grandson of the deceased. In the written objection filed by the OP for a month. Written of which was the backbone, the entire case, the period is for the provision of parties. They need to have interest in the estate of the district to come and see the. So the petition filed under order 6 rule 17 was rejected.
Then regarding the financial capacity, the will, it has been mentioned that more Kunu Santan Sampan user about the more they are all financially stable. It has been mentioned.
Doctor says that she was mentally fit. Only. Who is Ravindra Narayan Mandal?
He was the advocate also. the writer, the will.
Yes, let us read it. Will. You're coming to page 4 of the will.
Yes.
That is the relevant thing.
মোৰ মৃত্যুৰ পাছত মোৰ উক্ত নাতি শ্ৰীমান প্ৰীতম মুৰাৰী বাপতি যদি নাবালক থাকে,
Where you are reading?
starting from page, hold on, I have to 35 page.
Internal page of the will 3.
Here it is mentioned as page,
You have taken it handwriting. Okay, more
it starts
Issa.
from page 5.
Isare. Okay, you read it.
মোৰ মৃত্যুৰ পাছত মোৰ উক্ত নাতি শ্ৰীমান প্ৰীতম মুৰতে, start from page 5.
Yeah, but
মোৰ মৃত্যুৰ পাছত মোৰ উক্ত নাতি শ্ৰীমান প্ৰীতম মুৰতে বাপতি যদি নাবালক থাকে, তেন্তে চৰম পত্ৰ কাৰ্যকৰী বা এক্সিকিউট কৰাৰ বাবে তেওঁৰ পিতা শ্ৰীমান ভূপেশ প্ৰধানীক চৰম পত্ৰ প্ৰৱেশ কৰাৰ বাবে মই তেওঁক নিযুক্ত কৰিলোঁ। ভগৱান নকৰক যদি মোৰ নাতি শ্ৰীমান প্ৰীতম মুৰতে বাপতি যদি নাবালক অৱস্থাতে পৰলোক প্ৰাপ্তি ঘটে, তেন্তে তেওঁৰ তেওঁৰ পিতা শ্ৰী ভূপেশ প্ৰধানী মোৰ জ্যেষ্ঠ ল'ৰা শ্ৰীমান ভূপেশ প্ৰধানী উক্ত দক্ষিণ খনিজ সম্পত্তিৰ মালিক বৰ্তমানৰ দখলদাৰ হ'ব। মই এই চৰম পত্ৰৰ দ্বাৰা শ্ৰীমান ভূপেশ প্ৰধানীক এক্সিকিউটৰ নিযুক্ত কৰিলোঁ। He was the maximum beneficiary of all the cases. Other people or death.
no. First part she says, as he is Nabalok, I give him the part. Then also
Second
she,
part was mentioned that I appointed him as executor.
so there the problem is. So he had the right to apply. So he applied it. Solemn duty.
Question is not it.
And the cross-examination which you have done, you have destroyed your own case.
The will has been mentioned by the right that all my sons are financially established. They are living happily. They are one property. On that case, it cannot be presumed that he was suffering from financial commitment.
Let us not go by that.
And at the time of writing of the will, his grandson was aged about 9 years. And after 9 years, but below is 19 years. Under 10 years, it has not been explained.
What has not been explained?
time of the will, the grandson, Bhakti, his age was 9 years old. After 9 years, he will become major. And there will be another 10 years. That part has not been explained. If we assume that it has not been filed,
You were a student. You have got that out in the cross, which you never said so. You should have been silent on that. You asked him and he answered it.
so that has been decided because issue has been framed. Now, trial court has not elaborated discuss about the limitations of this part. Because once an issue has been framed,
No, it is not there, but from the evidence, one can very well, this court can exercise under order 41 and 24. Yeah, the evidence otherwise of these persons seems to be there. But he has signed out there, yes, and more particularly the evidence of the doctor. And he didn't put any question out there.
but
He in fact answered the question which you are posing, white harm impression. He said that she though was educated, but she was trembling. Because of her health, she would be trembling and she could not.
the PW1 or chief in his cross admitted that she was mentally very weak at that time. And whether she was in a position, whether she was known to the consequence of the will, that has to be decided.
A doctor was there. Doctor said that she was mentally well to execute it. You should have some contradicted that. The doctor's evidence is damaging for you. Otherwise, everything was good. What do you say, Mr. Prakash, sir? Help your friend out.
Definitely, my lord, I have support the judgment, my lord.
Huh?
I will support the judgment.
Obviously,
My lord,
you have
basic,
been engaged for that.
my lord, basic requirement, as I understand, my lord, subject to what my lord said. Whether the execution of the will was put on in terms of section 65 of the Indian Constitution. Number one. Number two, whether in terms of execution code of section 59 of the Indian Succession Act, whether he was in sound state of mind, testamentary capability or capacity, whether she was, whether it has been proved, and all other, my lord, suspicious circumstances. Of course, my lord, it is the propounder who is to dispel or remove the suspicious circumstances. But once he was taking the allegation of fraud, it was done collusively, it was done fraudulently, then burden will be shifted.
No, if it was done fraudulently, the burden will shift upon them. There's no quarrel.
My lord,
But then also, when they is an allegation of fraud
Yes.
or that she was not well, the burden is on you to prove that she was.
How
She
many
did it
state of mind?
with her own proper senses.
And therefore, my lord, lordship,
There was no suspicious
Right.
circumstances.
therefore, my lord, to answer this question, I can refer to evidence of PW2. He's a doctor, he's a home physician. No any particular question was put to my lord PW2. Therefore, my lord, once you have.
That is why I'm saying now,
Right.
where the cross should have been done, that
Yes.
was not done. They
Yes.
put the cross on him
Yes.
in respect to the delay,
Yes,
and he answered it.
answer. And my lord, PW2 also to the extent of my lord heart, my lord, physical problem. He said, my lord, last line, it is referred in judgment at page 21. I saw her trembling at that time.
That
Dr.
is the-
rightly pointed out.
That is why, and this
Yes.
is further being supported by that person who was the
Right.
petition writer in his cross. He categorically said that
Right.
she wanted to sign, but she could not. And as such, this is being done.
Right.
Which is the explanation which he could have put it as a suspicion and before me, that is being answered by the witness.
On the other hand, my lord, they are raising the question that she is quite educated, literate. The provided the occasion for her to, my lord, put her memory. Definition says, my lord, 63. Let us see the, my lord, section 63. There's no option.
Section
section 63.
63.
Clause A. The testator shall sign or shall affix his mark. Option, in a given situation, the testator may affix his mark, and it is altogether not necessary. Any person authorized by testator
No,
may.
no. There is no quarrel with that. I don't think Mr. Kolita will say that it is not that one cannot put the thumb impression. See, he wants only to put the suspicious circumstances. That this thumb impression is being put only for the purpose that to make it more suspicious. But the fact remains, whatever may be, when he put that question during cross-examination, he got that answer why it was done.
And my lord, some decision I have found, my lord, of course, one decision. Once execution is proved, allegation of fraud, allegation of suspicious circumstance no longer exists.
No, no, that is not that. That is the recent judgment of the Supreme Court.
I
That
got
is
one
not
decision.
that once the execution is proved, it doesn't mean that the will is genuine. Will is would be genuine if it is done in accordance with the provisions. There is two things. Will being validly executed, one is will being genuine. If it is under suspicious circumstances, maybe it has been properly executed.
So then my lord, question will arise, my lord, what is
Then
the-
also, if it is a person concerned who did not know anything, then that is what the Supreme Court said recently in that judgment where he is referring to 2025 QSC. That if it is a will, there is a difference in a will being executed and will being genuine. A will may be properly executed, but may not be genuine if it is under suspicious circumstances.
Then my lord, unless and until there is some, my lord, evidence on record that we fail to dispel the, my lord, suspicious circumstances, then question would have been otherwise. There is no any positive question was put to any of them. Therefore, that part goes. And so far as the, my lord, limitation part is. Now, when there is a question of delay, they are raising this question. I can understand, my lord, what lordship has said in your lordship judgment. The delay will not come. There is a distinction between application to apply for probate and application to revoke the probate. And one decision from Delhi High Court says, section Article 137 will apply only in case of, my lord, revocation of probate. Otherwise, no.
No, no, 137 will apply for application of probate also. But,
When, my lord, right to
But-
apply,
but the question is right to apply.
therefore it depends upon
The
necessity.
right to apply is, it depends. It is after all, it's a Solomon duty.
Yes. Supreme Court has, my lord, Supreme Court has, lordship knows, my lord, in case of converted Singh, it is a leading case. And there is a reference of this decision, my lord, one reference of the Bombay High Court judgment. And Bombay High Court says, my lord, when necessity arises. But if I say that I don't have necessity, I need not. On the other hand, my lord, let us see the background of the case. All legal heirs, my lord, they were made party. They did not contest the, my lord. And one of the, my lord, legal heirs, daughter, my lord, I think, my lord, is number 5. She filed WS, asserting that there is a will. And so far as, my lord, other properties are concerned, there are a number of cases. So far as this particular property is concerned, there is no case. And he had the knowledge, there was a will. And assuming that there is no will or will was otherwise not genuine, he could have made an claim, my lord. So far as his share is concerned, during the 10 years, now they have also filed an affidavit in this court, my lord, connection with this appeal, saying that will is genuine.
Huh?
Will is genuine.
We will.
There was a will
Right.
executed by my mother in favor of the grandson. There is the affidavit they have filed, my lord, before this court.
A5.
Other legal issues,
Not legal.
other responsible.
Whether they say or not, that hardly matters. We are only concerned with whether you have been able to remove the suspicious. So the will have been executed. There is no quarrel with that.
And what are the such circumstances, my lord?
which I think you have been able to disperse.
Yes, my lord, they have mentioned in their appeal itself, my lord. These are the suspicious circumstances. Now on the basis of
So
evidence,
now, Mr. Prakash,
I know.
I'm satisfied with your case.
my lord,
If you further argue, I will allow you,
my lord,
but later on I will subtract it from other matters during motion days.
There are one more contradiction.
my lord, if your lordship, my lord,
I am in your favor. You take a seat.
I'll not say, then I'll not say anything.
Yes. Otherwise, I'll subtract.
Yes, I'll not say.
PW1 has stated in his evidence lordship that the will has been prepared 2 days before the chamber of the advocate. But PW2, the advocate stated that it was prepared the house of the testator.
No, the wheel cannot be on the first day. It cannot be. He was asked to go there. He had talked there, and then he prepared. This is how it is. He went out there to call the advocate that my mother wants to make a will. Will. Advocate comes over there and then comes and talks to her on the basis of that instruction. The will is prepared. Anyways, let us dictate now. You fought tooth and nail. So Mr. D. Golita happens to be the expert in will matters. This is my second judgment on will. Courtesy, Mr. D. Golita.
The earlier case was also argued by people.
Huh?
Your judgment, lordship judgment.
Yeah, that is right. Now, in that case, it went in his favor.
Yes,
In fact, at the time when I first, that is another case. When I first delivered the judgment in open court that day, then I was against him. I was in favor of him, Mr. Somali. Then when the draft was placed before me, then I thought, no, in view of this another judgment, the recent judgment of where I have referred to, I looked into it, then I again fixed the matter for hearing of both the parties, and then I put it to Mr. Samaria, the question out there, and then I passed the judgment again on the next.
Section 281, that is,
Huh?
section 281, that
Ah.
is actually considered.
It is very confusing. Very difficult. In fact, his right to apply, which is there, the Supreme Court have held it that 137 applies.
Right.
But it being a solemn duty, which is being put for the purpose of probate or will, it is not there for the purpose of, otherwise for arbitration, if you move a section 11, once the dispute arises, your right to apply starts. Because 137 only says about right to apply.
okay.
But here, your right to apply does not start till you wish to do so. That's the difference.
That's the difference.
Hello.
And it is nothing but an application seeking some recognition of the court that I want to perform my duty. His status is nothing but a testamentary trust.
In fact, a will can be registered later on also. That is the only document which can be registered in absence of the testator.
Yes.
Otherwise, there is no other document. That is why it is, and I think it's section 41 of the Registration Act. It creates an exception. Anyway, good thing. Let us be heard Mr. D. Koilkar, the learned counsel appearing on behalf of the appellant. Mr. A.K. Pukasta appears on behalf of the respondent numbers. All the respondents, huh? Respondent numbers?
No, only no one.
You can't appear for all the,
No, I cannot.
then the collusion is apparent.
Here he is. Somebody else appeared on behalf of others.
For whom are you appearing?
Upesh Pradhan.
Appears
Yes,
on
right.
behalf of the
Legal,
respondent.
Legally also,
appears on behalf of the legal heirs of late Bhupesh Pradhani. Who was the original respondent number one. This is repeal under section 299 of the Indian Succession Act 1925, for short, the Act of 1925, challenging the judgment and order dated 9/8/2011, passed in Miss Probate case number 7/06. First, this court, before taking up the grounds of objection raised in the instant memo of appeal, would like to first deal with the facts which led to the filing of the instant appeal. One Hero, what is her name?
Hiron Prabha.
Hiron Prabha Pradhani had executed a will dated 11/7/1987, alleged to be executed by Hiran Prabha Pradhani, brackets since deceased, was put
madam, date of execution would be 11/5, 11/5.
11/5 or 11/5/7?
11/5.
11/5.
She died 11/7.
11/5/2000, 1987, was put to execution, was a will purportedly prepared by by late Hiran Prabha, by one Hiran Prabha Pradhani, since deceased, dated 11/5/1987, is the subject matter of the instant proceedings. Her son, Bhupesh Pradhani, since deceased, during his lifetime, filed an application seeking probate of the will dated 11/5/1987, whereby 1987, which was registered and numbered as Miss P 7/2006. Pursuant to the filing of such the said petition. The appellant herein, who was the opposite party number one in the said proceedings, filed a written statement contesting the said will. It was the case of the appellant herein in the said written statement that after the death of his father, his mother, late Hiran Prabha Pradhani, was living with him in his house since the first part of 1985. And since first part of 1985, she was ill and was suffering from breast cancer, for which she was treated with cobalt therapy from 1985 at Bhubaneswar Borua Cancer Institute at Guwahati. During her stay, she never expressed anything about her intention of making any will in respect to the property mentioned in the will in favor of the son of Sri Bhupesh of late Bhupesh Pradhani, or to anybody while she was living with the appellant. He, however, stated that 2 months prior to her death, she shifted to the house of late Bhupesh Pradhani. In the said written statement, the appellant stated that late Hiran Prabha Pradhani was bedridden from the time of treatment with radiotherapy from June 1985 till her last breath on 11/7/1987. And she was mentally incapable of giving any sound, valid, and proper consent and opinion during the said period. It was further mentioned that late Hiran Prabha Pradhani was a literate lady having knowledge both in English and Assamese, and she was a permanent member of the GB of Silarai College, Golakganj, where she used to sign both in English and Assamese in the meetings she attended. It was denied that late Hiran Prabha Pradhani had put her thumb impression in the will dated 11/5/1987, and it was alleged that the said document is a fabricated, manufactured document by late Bhupesh Pradhani and got the same registered secretly through unfair means without the valid consent and opinion of the alleged testator, late Hiran Prabha Pradhani, and without giving any cent to other opposite parties. It was also mentioned that the alleged will have been manufactured in fraud to deprive the other legal heirs and successors of the deceased, and the filing of the petition for probate on the forged will after the lapse of about 18 years is an act of conspiracy of the petitioner for unlawful gain and benefit through foul play. So it is pertinent to mention herein that late Hiran Prabha Pradhani expired, leaving behind various legal representatives, which included her son, which included two sons, three daughters, three daughters, and four daughters, and granddaughters and grandsons. Notices were also issued upon the other legal representatives, who, however, did not oppose the said probate application. Be it as it may, in view of which is that provision by which it becomes a suit
Some 295.
to
90.
be it as it may, in view of section 295 of the Act of 1925, as the probate proceedings was opposed, the said probate proceedings took the form of a regular suit according to the provisions of the Code of Civil Procedure 1908, for short the Code, in which the petitioner for the probate application that is late Bhupesh Pradhani, became the plaintiff, and the appellant herein became the defendant. Accordingly, the learned district judge Dhubri framed as many as 3 issues for decision. The 3 issues were: number 1, whether the probate petition is maintainable, barred by limitation. Question number. Number 2, whether alleged will was prepared fraudulently. And number 3, whether the petitioner would be entitled to any relief as prayed for. The records reveal that on behalf of the petitioner, that is late Bhupesh Pradhani, the following witnesses adduced evidence. Sri Bhupesh Pradhani, Sri Bhupesh Pradhani, that's PW1. Sri Ranjit Kumar Roy, Ray, dash, PW2. Sri Robindra Narayan Mandal, PW3. And Mohammad Mobinur Rahman, no, um, and number 4, Nogendra Chandra Datta, PW4. On behalf of the defendant, that is the appellant herein, he only adduced himself as a witness. That is DW1, OPW1. The plaintiff, on behalf of the plaintiff, on behalf of the petitioner, two documents were exhibited. That is the will as Exhibit 1 and the death certificate, that is Exhibit 2. On behalf of the on behalf of the opposite party, the appellant herein, three documents were exhibited. Exhibit A is the is an advice slip of Dr. Bhubaneswar Borua Cancer Institute, which shows that the testator, late Hiran Prabha Pradani, was under cobalt treatment from 1985. Exhibit B is a certificate given by one R.T. Bora, Assistant Professor of Surgery, Guwahati Medical College. Exhibit C is a, what is this? What is this Exhibit C?
I have not a copy of this.
Huh?
Exhibits are not available in here.
I Sri Hiran Prabha Pradani giving this consent that 12 Bora DB number 9362, which is standing in my name, in the name of my late husband, Bhuban Chandra Pradani of Golokganj, may be transferred in the name of the youngest son, Sri Vikas Chandra Pradani, and for this no objection will arise. Exhibit C is an undated statement of late Hiran Prabha Pradani, whose The learned first appellate court, the learned district judge, by the judgment, by the judgment and order dated 9th of August, 9/8/2011, allowed the petition filed by the petitioner, that is late Bhupesh Chandra Pradhani, Bhupesh Pradhani. In doing so, and thereby issued probate of the annexed will given in the schedule of the petitioner in favor of the petitioner. In doing so, the learned court below held that the probate petition was maintainable, and as there was no period of limitation prescribed, prescribed for seeking probate, the said petition was within the period, the said petition seeking probate was maintainable. On the question of the alleged, on the issue as regards the alleged, as to whether the alleged will was prepared fraudulently, the learned court below, after taking into account the evidence came to a categorical opinion that the will, that is Exhibit 1, was executed by the testator, late Hiran Prabha Pradhani, during her lifetime in respect to the scheduled land. It was further held that the evidence of the petitioner's side is quite believable, as because the petitioner, by adducing sufficient evidence, removed all doubts that circumstances, all the doubts, the circumstances under which the testator executed the will by putting her thumb impression. It was further held that the will in question was genuine and was not prepared by playing fraud. And accordingly, the issue number 3 was decided, thereby holding that the petitioner would be entitled to the relief as prayed for. Being aggrieved, the respondent, the opposite party, number 1, has preferred the instant appeal. This court, by an order dated 25/11/2011, admitted the appeal and by calling for the records, and records were called for. In the backdrop of the above, let this court now take note of the grounds of objections which were taken in the instant memo of appeal on the basis of the submissions so made by Mr. D. Polita, the learned counsel appearing on behalf of the appellant. The learned counsel submitted, learned counsel for the appellant submitted that there is no explanation in the probate application, in the petition seeking probate, as to why there was a delay of 18 years in filing the probate application. He submitted that though the settled law stipulates that section 137 of the first schedule to the Limitation Act 1963 applies, which means that the application has to be filed within 3 years from the date when the right to apply accrues. There is a requirement that this aspect of the matter should have been stated in the pleadings. He submitted that the learned First Appellate Court, the learned court below, merely decided the issue number 1 without coming to a proper finding as regards as to whether the seeking probate was barred by limitation. Number 2, the learned counsel for the petitioner further submitted that the testatrix was a literate person and she knew how to write in English as well as in Assamese. However, in the Exhibit 1, her thumb impression has been put, which raises great suspicion about the genuineness of the will. Number 3, the learned counsel submitted that the testatrix was suffering from breast cancer and she was not in a proper state of mind to execute the said will. This aspect of the matter was not taken into consideration by the learned court below in passing the impugned judgment. Number 4, the learned counsel submitted that a reading of the will would show that late Bhupesh Pradhani did not have the right to apply after the beneficiary had attained the age or had become major. He submitted that the beneficiary in question, he submitted as on the date on which the purported will was prepared, that is on 11/5/1987. 87. The beneficiary was 9 years. At the time when the will was, the application seeking probate was filed, the beneficiary, that is after 18 years from the date of execution of the will, purported execution of the will, the beneficiary had already become a major. And as such, the late Bhupesh Pradhani did not have a right to apply for probate. He therefore submitted that these very aspects of the matter were not at all taken into consideration by the learned court below. Anything more?
281. 281.
What is that?
When a person apply for a probate, one of the attesting witness, the will, there should be a verification with the respect.
He further submitted that when a will is being filed, prepared, a petition is being filed. Seeking probate of the will. The will has to be verified. The said petition has to be verified by at least one of the witnesses to the will. In the instant case, it will be seen that the petition seeking probate did not include any verification by one of the attesting witnesses. The protester, I'll put your submission and coming back. That putting into execution a will by seeking probate is the solemn duty of the testator. Under such circumstances, the right to apply shall only accrue when necessity arises. He therefore submitted that though the will was put into execution after 18 years from will was put, though he therefore submitted that though the petition was filed after 18 years from the date of from the execution of the will, the same has to be taken into account on the basis of when the right to apply had accrued. He submitted that from the evidence on record, it could be seen that the petitioner, that the petitioner's son was a student, and the petitioner was having financial difficulty. And as such, the said aspect was duly placed before the learned court below. Next. The learned counsel for the respondent, number one, respondents, number, for the respondents, number one, for the legal aids of the respondent, number one, further submitted that the evidence on record will clearly show that the will was validly executed and was also and the will was also a genuine will. He submitted that when a will is contested, when a petition seeking probate of a will is contested, the propounder of the will has to prove that there was no suspicious circumstances under which the will was prepared. Referring to the evidence, more particularly of the petitioner number one and the petitioner number two, who was the doctor, he submitted that the suspicions so being sought to be raised by the opposite party, that is the appellant herein, was duly addressed. He stated that the evidence of the PW2 clearly stated that the testatrix was in sound state of mind. And this evidence, under no circumstances, would be, and this evidence of the PW2, who was the doctor, could not be dislodged during cross-examination. Further referring to the evidence of the cross-examination of PW2, the learned counsel further submitted that a doctor had categorically stated that the testatrix at that relevant point of time was trembling. Her hands were trembling. And she had put her thumb impression. Further referring to the evidence of PW3, the learned counsel submitted that the said witness not only stated that the testatrix informed him as to how the will was to be prepared, but during his cross-examination, he further stated that the testatrix, though wanted to sign, but could not sign, for which the testatrix had put her thumb impression. The learned counsel therefore submitted that the question of the testatrix being illiterate, and as such she could sign the will, have been duly explained in the evidence of the PW1, 2, and 3. Further referring to section 61, 63A, bracket A, of the Act of 1925, the learned counsel submitted that the testatrix could sign or put or could affix her mark. And in the instant case, she had affixed her mark by putting her thumb impression. He therefore submitted that the learned court below have, after taking into account the evidence on record, had come to a finding that the will was validly executed, and as well as the will was genuine. On the question of violation of, on the question of infraction to section 281, the learned counsel submitted that there is no pleadings in the objection that the petition the petition suffers from the defect of verification made by one of the witness. There is no verification of one of the witnesses, attesting witnesses. Be that as it may, the learned counsel submitted that a perusal of section 281 further shows that it is not mandatory that there has to be a signature, the attestation, there is that it is to be verified by the witness, as would very much appear from the language of section 281 itself, which stipulates the words, inverted comma, upper bracket, when procurable, bracket close, inverted comma closed. He therefore submitted that this very issue, that the violation, that the infraction so said as regards section 281 of the Act of 1925 does not hold good. Anything else, Mr. Prakash?
You have pointed out Article 137.
That I've already said. Anything, nothing more.
My lord, I have also argued by referring to clause exclusion 4 of section 59. She was already pointed out that whether she was in sound state of mind, having the capability to understand the consequence of what she is doing. That part can be accepted by referring to my lord evidence or PW2.
Which one? Explanation 4. No person shall make a will while he is in a state of mind, whether arising from intoxication or illness or from any other cause that it. No, that I have already taken care of. I've already said. On the basis of the above submissions, this court frames the following points for determination. Number 1, whether the petition filed seeking probate was barred by limitation. Number 2, whether the will, that is Exhibit 1, was validly executed, and whether and is a genuine will of the testatrix. Number 3, whether the learned whether the will was maintaining, whether the petition filed by file seeking probate of the will dated 11/5/1987 was maintainable on the ground that no attesting witness had verified the said petition. These are the three. And number 4, did you? Whether in any view of the matter, the impugned judgment and order requires interference. Let this court first take out the first point for determination number 1. Underline. The said point for determination pertains to as to whether the petition seeking probate of the will dated 11/5/1987 was barred by limitation. From the material, from the facts on record, it would be seen that the will was executed on 11/5/1987, and the petition was filed on 9/1/2006. And the petition seeking praying for probate of the said will was filed on 9/1/2006. In the case of Kerala State Electricity Board versus TP Unhalli Kaunhalliumma, reported in 1976 4 SCC 634. The Supreme Court, while distinguishing Article 181 of the Limitation Act 1908 with Article 137 of the Limitation Act 1963, observed that the limitation prescribed in Article 137 of the Act of 1963 shall be applicable in respect to a petition for grant of letter of administration or a grant of a probate. Further to that, the Supreme Court in the case of Kunwarjit Singh Kanpur, Khand Kanpur versus Kiran Kaur and others, reported in 2008, 8 SCC 6463, observe that a crucial expression in Article 137 of the Act of 1963 is inverted comma right to apply inverted comma closed. It was observed that an application for grant of a letter of administration merely seeks recognition from the court to perform a duty, and because of the nature of the proceedings, it is a continuing right. It was further observed by the Supreme Court in the said judgment that in an application filed for grant of a probate or letter of administration, no right is asserted or claimed by the applicant. The applicant only seeks recognition of the court to perform a duty. In addition to that, it was also observed that the proceedings filed for grant of probate or letter of administration is not an action in law, but it is an action in rem. In the case of
Have taken the same view.
huh?
Have also taken the same view. In Shurata Pal.
Let me not refer to my own judgment. It is also seen that in another recent judgment of the Supreme Court in the case of Samir Kapoor versus State, two subdivisions reported in 2020 12 SCC 480, the Supreme Court categorically observed that right to get the letter of administration is a continuous right which can be exercised at any time as long as the right to do so survives and the object of the trust exists or any part of the trust, if created, remains to be executed. Taking into account the law so settled, let this court take note of the submission of Mr. D. Kolkar, the learned counsel appearing on behalf of the appellant, to the effect that Exhibit 1 which is the will, only granted the petitioner, that is late Bhupesh Pradhani, the right to apply only when the grandson of the testator, right to apply till the grandson of the testator did not attain the age of majority. This court have duly taken note of the contents of the will. That's Exhibit 1. From the contents of the will, there appears to be two. It is very clear that at the time when the will was prepared, the beneficiary was a minor. And as such, late Bhupesh Pradhani was entrusted with the duty to execute the will, to file a petition seeking probate of the will. First. It is, however, it is further clear. It is, however, relevant to mention that there is no mention in the will that after the beneficiary attains majority, the beneficiary would have a right to apply. Rather, a further perusal of Exhibit 1 would show that late Bhupesh Pradhani was appointed as the executor to execute, to seek execution, to file appropriate application seeking probate of the will. In the backdrop of the above, if this court duly takes note of the evidence, it would be seen that during cross-examination, late Bhupesh Pradhani further explained that at that relevant point of time, the minor, the beneficiary was a student, and on account of financial difficulties, he could not file the petition seeking probate of the will. Considering the above, that it is a continuous right, considering the above, and as per the settled principle of law, the right to get a probate is a continuous right which can be exercised at any time as long as the right to do so survives. And in the instant case, it survived. It is the opinion of the court that the filing of the petition by late Bhupesh Pradhani during his lifetime was seeking probate of the will dated 11/5/1987 was not barred by limitation. Number 2, second point for determination. The second point for determination is as to whether the will was validly executed and as to whether the will was a genuine will. This court finds it relevant at this stage to take note of a recent judgment of the Supreme Court in the case of Lilian Coelho, Coelho, and others, reported in Miera and others versus Miera Philomena Coelho, reported in 2025 2 SCC 633. wherein the Supreme Court distinguished distinguished the expression inverted comma will is validly executed and with the expression will is genuine. The Supreme Court observed in the same judgment that a will is validly executed when it is when the propounder establishes that the will was executed in accordance with law. On the other hand, for a will to be genuine, the propounder has to prove, the propounder has to remove such suspicious circumstances to the satisfaction of the court. In view of the above expressions, explanation, in view of the proposition of law as held in the case of Lilian Polhello Supra, let this court now take up as to whether the propounder of the will, that is the petitioner, have proved that the will was validly executed and further have been able to establish that the established to the satisfaction of the court that there was no suspicious circumstances. From the evidence on report, it would be seen that PW1, from the evidence on record of the PW record, that is the evidence of PW1, PW2, and PW3, it would be seen PW1, PW2, PW3, as well as PW4. It would be seen that not only the propounder of the will, the executor, but also the attesting witnesses, as well as the registering authority had proved on the basis of the evidence that the will in question was executed by the testatrix by putting her thumb impression in their presence considering the said evidence. This evidence of the PW1, 2, 3, PW2, PW3, and PW4 in respect to the execution of the will could not be dislodged during the cross-examination by the defendant, by the appellant herein. Now let this court, under such circumstances, it is the opinion of the court that the will in question was validly executed. Not during the could not dislodge during cross-examination. It is further say, relevant to mention, that there are allegations being made in the written objection so filed by the appellant herein that the will in question was a fraudulent document. However, the appellant could not prove on the basis of any evidence that the will in question was a fraudulent document. Considering the above, it is the opinion of the court that the will in question was validly executed. Now the next question arises as to whether the propounder of the will, that is the petitioner, could dislodge, could establish that the will was not executed in suspicious circumstances. In this regard, it is relevant to take note of the stand taken by the appellant to create the suspicion. First, it is the case of the appellant that the testatrix was suffering from breast cancer. And at that relevant point of time, as she was under the cobalt therapy, she was not in a position to have a sound state of mind to execute the will. Second, the testatrix was a literate person, and she knew how to read as well as write in Assamese and as well as in English. However, the will in question contains the thumb impression of the testatrix, which creates reasonable suspicion. And third one, these are the two.
She has left her place for 4 months. Because he was under the influence of the petitioner also at the time.
I think that is too much. Anything better? These are the two. When she was not, she was okay. Thirdly, as the testatrix was under the care of the petitioner, that is late Bhupesh Pradhani, she was influenced by late Bhupesh Pradhani to execute the will. This court, for the purpose of taking up these reasons for suspicion, the grounds assigned to create a suspicion on the execution of the will, finds it relevant to take note of the evidence of PW2, who was an oncologist and was treating the the testatrix. In his evidence, in his examination in chief, he had categorically stated that he used to attend the testatrix on call and that she was a breast cancer patient. In his evidence, he further stated that at the time when the will was executed by the testatrix in his presence, she was suffering from neurological problem causing general weakness to her health. He further stated that due to the said physical weakness, she could not put her signature in the said will, but she put her thumb impression. He further gave evidence. He further stated in his examination in chief that he found the testatrix to be mentally fit at the time of execution of the will. This court duly takes note of the cross-examination of PW2. Wherein he confirmed to what statements he made in his examination in chief. He further stated on cross-examination that the testatrix used to take meal herself at the time of ailing. He further stated in his cross-examination that he saw her trembling at that time. And what is the next line? She was the last line of his cross. She was the last line of PW2's clause. Huh? What is the last line?
He was educated member. He was an educated.
No, last line is, my lord,
She was educated member. And she was, no, it can't be twice the same. She was
Educated member.
educated member and she was educated woman
Woman.
and
She
put
put
her
her
signature.
Put her signature.
He further stated that she was an educated member, that the testatrix was an educated member, woman, and put her signature. This court further finds it relevant to take note of the evidence of PW3. Who not only stated that the testatrix had put her thumb impression in his presence, but also stated that he took the thumb impression of the executrix. Further, he stated that she initially tried to sign her name in writing but could not. For that, she used to put her thumb in the will. The above evidence of PW2 and PW3. Therefore, makes it clear that that although the testatrix was suffering from the ailment of cancer, but she was in a position of disposition. She was in a position to execute the will. There is no evidence produced, on the other hand, by the appellant herein to the effect that at that relevant point of time, when the will was executed, the testatrix would not have been in a sound state of mind. So, the allegation, the reason, the ground of suspicion created on the basis that the testatrix was under the care of the petitioner at that relevant point of time, in the opinion of this court, is not sufficient to dislodge a validly executed will. Considering the above, this court, therefore, is of the opinion that the will in question, that is Exhibit 1, was a validly executed will, and the will was genuine. Third point for determination. The third point of the determination pertains to as to whether whether on account of there being no witness who verified the petition filed by the propounder, the entire proceeding should be allowed to should be rendered non-est. This court duly takes note of that such a plea was never raised by the appellant in his cross-objection, in his written objection. This court further takes note of the provision of Section 281 of the Act of 1925, which stipulates that the verification of the witness would only be necessary, has to be done on the basis if the witness is procurable. Under such circumstances, it is the opinion of this court that the provision of Section 281 of the Act of 1925 is merely is directory enough, is directive, and it would only depend when such a witness can be procured. Under such circumstances, it is the opinion of this court that merely on the ground that the petition so submitted seeking probate did not have the signature of did not have the verification of the attesting witness, the entire proceedings cannot be said to be non-est. Additionally, this court further takes note of that the PW2 and PW3 were the attesting witnesses, and they have duly given evidence to the effect that in their presence, such a witness, that the testatrix had put her thumb impression, and this evidence could not be dislodged. Considering the above, it is the opinion of the court that the petition filed by the by late Bhupesh Pradhani seeking probate of the will cannot be said to be bad on account of there being no witness who had attested the had had there was no witness who had signed the verification in the said petition. Number 4.1. Considering the above, comma, this court have also perused the judgment and order, impugned judgment and order dated so and so passed by the learned court below. It is the opinion of this court that the learned court below have duly addressed the issues as per the settled principles of law and had also duly taken note of the evidence on record. Considering the above, this court is of the opinion that the impugned judgment and order dated so and so, passed in so and so, does not call for interference. Accordingly, the instant appeal stands dismissed. Comma. This court affirms the judgment and order dated so and so, impugned judgment and order passed in so and so by the court of the learned so and so, District Judge Dubri. Number 2. This court further imposes a cost of rupees 20,000 upon the appellant. In addition to that, the appellant shall be entitled to costs throughout the proceedings. The records be read out.
I'm grateful.
Problem.
Item 2.
Yes.
Please, Your Lordship. Your Lordship, the LCR has not been received in this matter as yet.
What is the issue? I don't see normally as LCR. What is the issue involved?
Your Lordship, the main ground of appeal.
Yes.
Your Lordship, we have filed an application in the order 41/27, which is the verification report of the driving license of the driver of the alleged offending vehicle. What our ground of appeal is, Your Lordship, is that the driver at the time of the accident was not having a valid license. And so it was
You are
the
driver?
Yes, Your Lordship.
You are the owner or driver?
Put a claim in. Owner
No.
driver does not contest.
owner and driver
Does not contest the claim.
in the tribunal also, the case proceeded ex parte, they did not appear. But here, Your Lordship, before.
How do you say that the owner did not have the year? Did you say that the driver did not have a license in your written statement?
Yes, Your Lordship. We have taken a general defense in the written
General-
statement as
No,
well.
general defense won't do. Did you take it properly?
Yes,
Why you said so?
Your Lordship, this is the written statement.
You got how much money?
Not a single thing.
Why?
Because the appeal has been admitted without
With no interim.
judgment has been stated. Asking for the yeah. Their whole ground is that after pronouncement of the judgment, they have received a report from the DQ Suraj Chandrapur, wherein it is stated that at the time of the accident, the driving license was not renewed. And therefore, they have filed this, along with this appeal, filed an application under order 41/27 for taking into that account.
Your Lordship, para 7 of the written statement. It is specifically submitted that the driver of the accident involved vehicle was not holding a valid and effective driving license at the relevant time of the accident.
Why did you say this in your statement?
Your Lordship, we had this doubt that the driving license was not valid. So in the year 2016 itself, we appointed an investigator to get hold of the details of the driving license, Your
So
Lordship.
you made this statement without the verification.
Your Lordship, we already sent a request to the investigator. The investigator filed an application in the RTI Act.
Accident happened when?
2014.
2014 January.
So you knew about it. What were you know? Why did
But
you
your
do
lordship, the
anything?
investigator's report was not received back. At that time, we did not receive back the report from the investigator, so we could not take any steps. And, but when we were processing the file here, we got hold of the investigator report, and then that's when we learned that the deal was not valid and effective. And so your lordship, we
You
filed this
raised that
application.
issue before the trial court. That the license did not have the license.
There is no such issue. Lordship. They have not reduced any evidence. There is no specific.
Right in the same accident took place, whether he. So you never
Your
raised that
lordship, the
issue.
main reason why we did not raise this issue before the trial court was there, the Caesar list was there, your lordship. As per the Caesar list of the offending vehicle, the license was valid till 1st of January 2015. And the accident occurred in January 2014. Your lordship,
Accident happened when?
accident took place
2015.
18 January 2014. And as per the Caesar list, which was exhibited by the claimants, it was written that the expiry date of the driving license was January 2015. So we, according to the Caesar list, the license was valid. But we had this doubt, so we appointed an investigator who filed an application under the RTI. But the report of the investigator was not received back, and in the meanwhile, the judgment was pronounced.
Did you ask for time?
Your lordship, I'm not sure about that, your lordship.
No, no.
You don't do you. You are not challenging elsewhere any.
The quantum, we are not challenging the quantum mainly, your lordship. Our main,
So you do one thing, you pay and you recover from him.
from the owner, your lordship.
File application, prove it. Prove it before them. Why should I look into these aspects here?
Your lordship, order 41 rule 27, if the court finds that there's some lacuna or defect in the judgment, which can be cured, then additional evidence can be accepted, your lordship. There are a bundle of judgments which I can produce before this honorable court for this document to be accepted, your lordship. Your lordship,
Where
there's
is
the,
the evidence that it was? You see, I am to verify the license number in respect of who is given it? Where is the verification given? What documents you are enclosing?
your lordship, page,
Page 25, Lordship.
your lordship, 24 and 25 of the memo of appeal.
So who is he to give this?
Your lordship, if you see the page 25
No, you
the
are
bottom-
saying about page 8 and 9.
of IA 845.
I 45. This is all by your investigator. He may say anything.
Your
What
lordship,
relevance does it have?
no, your lordship, page 9, the bottom part.
It's written by whom?
This is from the DTO, your lordship. This is the sign and seal from the DTO to Chandpur district. So this is the format, your
Now,
lordship.
whether this driving license was further extended after a year, is it mentioned anywhere? Then, how is it relevant?
So it is,
Are you saying for the last 4 years he did not have?
it is for the owner to prove the validity of the license, your lordship.
So if the validity, go and prove it. You say something, take over action, pay him the money. Why do we need the records? Put the records.
Lordship, as for the Belly Rama case, the owner is not only responsible for valid license, is also responsible for its renewal. To prove
Your
it.
evidence, what you have submitted is not sufficient. That evidence cannot be sufficient. Does it say that in 2000, that very license was not renewed? That is not the answer in that. What do you want? There are two ways of going. I'll take up order 41 rule 27 says that this is absolutely useless. I am not going to. But as regards there's the other issue out there, I can very well say that allow, pay the money, go and file an application before a year, the tribunal will consider allowing both the sides to use evidence. But you have to pay him.
In that case, your lordship, the interest on future prospect must be waived off at least for during the COVID period, your lordship.
Right.
Your lordship, in the judgment, interest was paid on future prospects also, but as per the judgment of this honorable court itself of Justice Kalyan Rai Surana and most such judgments, your lordship, interest cannot be paid on future prospects. So your lordship, in the compensation amount, if that amount is waived off, your lordship, we can proceed with the payment and then recover from the owner as per the Nanjappa case.
Interest on future prospects.
Yes, your lordship.
But I am of the opinion one should get interest.
Otherwise also interest has been less awarded only 6%.
We do one. We'll remove interest on future prospect, we'll make it 9.
No,
Normally it is 9 everywhere. Recently,
yes,
our
but
all
lordship
judgments
does
are
not
nine.
actually allow.
it's between 7 to
Mm.
7.5. 9 is highly exorbitant.
Sir, everywhere 9 is even, so we make it
No,
9.
lordship, it's
and
mostly
give
7
you
to 7.5, not 9.
9. We
Nine
give it
lordship does
9
not
and
agree.
remove it from there. Okay,
No, lordship.
don't go into all these things. You make the payment and then take it from whatever will be asked from them.
Your lordship may at least make an observation that the owner in the tribunal, he must be directed to furnish some security before the release of the amount. Your lordship, as per the Nanjappa case, if the owner is responsible and the insurance company is not, then it becomes very difficult for the insurance company to recover from the owner because owner is not appearing, neither in the learned tribunal below nor here, neither here. So, your lordship, if they furnish some security, in some cases, the offending vehicle is attached. Your lordship, we may get some security so that the money may be released. Your lordship, I may produce this.
First, madam, you have to prove. Why? To prove that first you have to prove that yes, he did not have. Prove that. Not on this document is insufficient. The better off this issue, let it be raised there. So we dispose it out here, we pay this amount. That day I passed one judgment, na, where I have given the opportunity, giving you some period to file, deposit it before the tribunal, the entire money. Tribunal will appropriate the money in the manner in which the judgment has been given, how it is. And thereupon, you file also your application giving you liberty within such a period to file an application. After you file, they will issue notice. You prove what and giving you the opportunity to produce evidence. Matter solved.
Your lordship, time will be given 1 day to just confirm about the expiry of the driving license.
That is.
No, whatever may be, you go and prove it there. You have to pay. You had an insurance, you paid. Later on, we'll look into it. See the other judgment, made the other decision. You see, doctor? Give it to me. Doctor, no? Yeah, it was the judgment site, I can get this. That is the order which is going to, I'll dictate it in the phone. This is the order you are going to get. If you want interest on future prospects to be waived, I will waive it, make it nil. Make it same. Which one?
No, the judgment as it is fine then, your lordship.
Ask your senior, we'll take it up with two and some other matters, then I'm going to pose it.
Okay.
Today, this is the end of the. Let me come back. Order of cancellation of registration dated 18/11/2019, challenging so and so is set aside in cost. The petitioner herein is directed to file the returns for the period from the date of cancellation of the registration 18/11/2019 till date within 30 days from the date of the instant judgment. The period is stipulated in section 7310 of the Central Act of the State Act shall be computed from the date of the instant judgment except for the financial year 2024-25, which shall be as per section 44 of the Central Act, the State Act. The petitioner herein shall also be liable to make payment of the arrears, that is taxes, penalty, interest, and late fees. Same for everybody. Because this you have filed so late, na? So that is why. There has been delay by me in delivering the judgment.
But if the day is also is favorable for us.
I have actually, see, I don't keep CB, so that is why this call is somehow. You see, it makes no sense in the Central Act or the State Act to deprive the persons from the registration once it is being filed. Taking into account that if you are doing the business, they have to compulsorily do under 25(8). But just for example, in the case of Mr. Todi, his case is in 2019. If he files his return now, 3 years is over. So they can't pass an order. So that is why 7310 is being broken.
Kept a balance between the.
So that is means you file, then only it will be from here. So otherwise, just for example, 73(2) also, you have to keep 3 months. So, but in the case of 24-25, it will end only in the month of December, 31st December. So therefore, for that 24-25, I have stated it will be as per the.
Even the department is protected.
Hmm?
Even the department is protected.
Even the department is protected. Let them do whatever they feel will be better. I have not interfered with the appellate order because they can't do anything in view of 107(4).
But there's a Supreme Court judgment just now, Lordship, just last week. They said that condonation of delay in limitation act will apply. Supreme Court has said, just last week. Yesterday.
Limitation Act will apply, but how do you apply it when the period is already given? Section 5 will apply, but if there is no period extent given, they cannot. It is a statutory authority.
They cannot, Lordship, but the court can always.
It can, because the Limitation Act can only be done by the court, but not by the,
Not by
not applied.
much of it.
Item 19, fixed.
It is very agreeable to pay the cost, but the lordship may kindly pose a lesser cost matter.
I said 1 lakh yesterday. Make it 50,000. Where's the other side? They are paying for whom?
Private is fine.
Private respondent. You filed your written statement, na?
Yes, sir.
My lord, although the written statement is filed on behalf of the defendant, but the.
Or you could not prove it.
Yes, my lord.
You
my case-
wanted to prove it, but you did not. Those two persons. Now, yes, now.
That's not filed by them, but it fixes yes, as by them.
So they wanted to prove it.
But Lordship, they have not appeared subsequently after filing.
Understood. That is why the cost of 50,000. I am relegating this matter back to that position of Order 9, Rule 13. I have heard Mr. A.K. Gupta, the learned counsel, appearing on behalf of the petitioner. Petitioner, petitioners.
Petitioner.
Matter has been, matter should not be structurally.
One petition.
Yes, sir, thank you.
Appearing on behalf of the petitioner. P.T. Borman appears on behalf of the opposite parties. This is an application filed under section 115 of the Code of Civil Procedure, 1908, challenging the judgment in order dated 6/3/2013.
16/3/2013,
Where is the judgment dated? Where is the judgment?
page 78.
16/3/2013. Passed in Miss Appeal number 8/2013, whereby the appeal filed under order 43-1. What is that? 1C. Is it 1C or 1D?
Order C.
1C.
One, that's it, paragraph, page 71.
1C.
Here is
1C read with section 104 of the Code of Civil Procedure 1908, for short the code, was rejected, was dismissed. For the materials in report, see that the respondents herein had filed a suit before the court of the learned Munsif at Mongoldo, which was registered and numbered as title suit number 8/1995. In the said suit, the petitioner herein was the defendant number 1, isn't it? It is a further seen that in the said suit, there is a, in the said suit, written statement was filed by the defendants. However, thereupon, nobody appeared on behalf of the defendants, for which the suit proceeded ex parte. And by the judgment and decree dated 8/7/1996, the said suit was decreed in favor of the plaintiffs. The plaintiff, the petitioner, the defendant number 1, on coming to learn about the said the judgment and decree dated 8/7/1996, filed an application under Order 9/13, which was registered as Ms. case number 8/08. It is the case of the petitioner, public the defendant number 1, in the said application, that they have never received any notice summons in respect to the said suit. And the written statement was filed on behalf of the defendant number 1, public the petitioner. By a certain person impersonating the defendant number 1. On the ground that the summons were not served upon the defendant number 1, and they only came to learn on 14/5/2008. From one Sama, son of late Ramzan Ali, that there was some ex parte decree dated 8706. The defendant number one oblique the petitioner made inquiry and could obtain the copy of the claimed written statement as well as the judgment, and thereupon filed the said application under Order 9 Rule 13. It is further seen that the respondents herein, who were the plaintiffs, filed a written objection to the said application filed under Order 9 Rule 13. Stating inter alia that the petitioner stating inter alia that the defendant number one oblique the petitioner had due notice about the suit as well as the date of hearing. Further to that, it was also stated that it did not constitute a sufficient cause for non-participation on the date of hearing. It is seen from the order dated, impugn order dated 4/5 from the order dated 4/5/2009, passed in Mizze case number 8/2008, that the petitioner oblique the defendant number one oblique the petitioner was afforded opportunity to adduce evidence as regards the fact that the written statement was not filed on their behalf. However, in spite of opportunities being granted, the counsel on behalf of the petitioner oblique the on behalf of the defendant number one oblique the petitioner did not appear. And it is under such circumstances, the order dated 4/8/2009 was passed, thereby rejecting the application under Order 9 Rule 13. It is further seen that pursuant thereto, the petitioner being the defendant number one oblique the petitioner being aggrieved preferred an appeal before the court of the civil judge Dorong, Moldoi, which was registered at Miss Appeal number 8/2009, challenging the order dated 4/5/2009. And the learned first appellate court, by the impugn order dated 16/3/2013, had set aside, had dismissed the said appeal, primarily on the ground that in spite of various opportunities being granted to the petitioner, oblique the defendant number one, they did not take steps for proving that the written statement was not filed on their behalf. And as they failed to discharge their owners, the learned trial court was justified in passing the order dated 4/5/2009. In the backdrop of the above, this court have heard the learned counsels appearing on behalf of the petitioner, as well as the counsel appearing on behalf of the respondents. And this court further have perused the materials on record. From the materials on record, it transpires that the case of the petitioner herein is that they did not file the written statement before the learned trial court. In title suit number 8/1995. It is the further case of the petitioners that some imposter had filed a written statement on behalf of the petitioner oblique the defendant number one. It is further seen that due opportunity was given to the petitioner oblique the defendant number one to adduce evidence in that regard. However, in spite of opportunity, the counsel on behalf of the petitioner oblique the defendant number one remained absent when the matter was taken up for hearing. From the above materials and report, it therefore transpires that the petitioner oblique, that the counsel appearing on behalf of the petitioner oblique the defendant number one were negligent in pursuing its duties. It is a settled principle of law that on account of the fault of the counsel, a party should not suffer. This court also fitted as it may, this court also takes due note of the fact that the negligence on the part of the counsel can also be that fitted as it may, this court further finds it relevant to observe that there are apparent laches and oblique negligence on the part of the petitioner oblique defendant number one. Insofar as not taking appropriate steps against the counsel for whose negligent conduct the order dated 4/5/2009 was passed. In this process, huge amount of judicial time have been wasted. Under such circumstances, it is the opinion of this court that if no cost is imposed in the present case, it would have an adverse effect on the administration of justice. Considering the above, this court, therefore, interfered with the order dated 16/3/2000, orders dated 4/5/2009, passed in Ms. case number 8/2008, 8 na?
Yes.
As well as the order dated 16/3/2013, passed in Ms. Appeal number 8/2009. And further restores Ms. case number 8/2008 to the file of the learned trial court, that is the court of the Munsif number 1, Moldoi. This court further imposes a cost of rupees 50,000 upon the petitioner herein, which has to be deposited on the next date, so fixed herein under. Taking into account that both the parties are duly represented, this court directs both the parties to appear before the learned trial court, that is the court of the Munsif number 1, Moldoi, on 21st of April 2025. On the same date, the petitioner herein, who is also the petitioner in Ms. case number 8/2008, shall deposit the cost of rupees 50,000, which shall be a condition precedent for the purpose of further proceeding with Ms. case number 8/2008. This court further observes grants liberty to the petitioners, the respondents herein, who are the opposite parties in Ms. case number 8/2008, to file appropriate application before the learned trial court for release of the said amount, and the learned trial court shall pass appropriate orders in that regard. The registry shall immediately return the LCR of Miss Appeal number 8 of the 2009 before the learned court before the learned court. Okay.
Item 18.9.
Did you get the calculation?
But I asked them. They have given.
Have you looked into Mr. Saturday? Three lakh 82,527.
Lordship, this is in respect of CRP 45, yes.
The other is 73,303.
No, they said it is 100, the last column, my lord. Last column, 1,11,540, 544, they said.
Oh, 1 lakh 11,000.
11,544.
544. Mr. Padanya, have a look.
It's not prepared as per the guideline given in that case, remember. They were asked to prepare a statement as per the guideline. That is not prepared like that. It is continuous of the old statement which they filed before the honor.
No, have you prepared?
I was,
To me, your
in two cases, I have to. Not known how it is appropriated against the interest, not for then principal, but. We have prepared it as per the guideline.
so one is 3 lakh 27,000. How much? 32 lakhs.
Pending interest, 24,38,509. For last 25 years, we have not paid the amount. So interest accrued.
And what is on the extreme right hand side? Is 65,000, 65 lakhs, 6 lakhs 50,000. What is this?
Regarding the payment made by them, there is no dispute.
No, you have, this is the payment made, amounts.
Yes.
Amount paid.
Amount.
So last payment made is of 21/12/2010 of
Yes.
7,492. Isn't it?
Yes.
So then on that day, what is then, what is the next column? What is this 2,90,000?
Last column,
What is the last column?
accumulation of the interest.
Oh, yes, I get it. So they paid this 10,000. So this is 65,000. And they pay another 10,000. So this becomes less. This is being added.
In the statement, they are not shown how it is associated. That is the main issue.
This seems to be like,
But I take the instruction copy. I'll take a copy and I'll take the instruction.
because what mistake you have done in your calculation is, you have again appropriated, you see this finally come to 10 at this one, the calculation sheet of yours, the SCRP one,
Logic.
the first one. You have paid 15 lakhs on 28/9/2000. Isn't it?
Mother.
15 lakhs you have paid. The first one.
While it is holding 45.14. CRP 45.
45.
45. Logic.
See, you have paid 28/9/2000, 15 lakhs.
15. 1,50,000.
1,50,000.
Logic.
1,50,000 or 1 lakh?
150.
1,50,000.
Logic.
Now, 1,50,000, if it is paid, this has to go from this 93,000. From there, it has to minus first there.
Logic.
And from there, some amount will go from here. So here it is 88. This is okay. There's no problem. Till here, there's no problem.
Mother.
Then on this, you have 0.5 years something, which 18%. Again, this is accrues. From here, it is okay. Then you pay 7,000.
70,000.
70,000. For this 70,000, remaining interest is 992.
9,900.
9,900. So this interest remains.
Logic.
So this again,
1,75,000.
here you again add, why you disturbing the principal here?
But after payment of 70,000,
So still remains this one, na?
9,000.
9,000.
9,000.
You are adding the 9,000 here. You should not. This is the principal, it remains. Then against this, there will be an interest of 18% for 0 points, which comes to 1,64,000, 1,16,000.
16,000.
Okay, so here you get it,
Logic.
84. This is 1,16,000.
1,60,000.
Then on here you have 9,000 already there.
Logic.
Then you pay 1,75,000.
75.
So from here again take this 9,000 out. So add this 1,60,000 plus 9,000, and then some amount will come down to 84,0248.
Mother.
Then you pay here interest next is for next 6 years, which comes to around 7 lakh is the interest.
7,
Okay.
One.
Now you pay only 1 lakh.
1,
6 lakhs remain. Till here it's okay.
lots,
Then
again 1 lakh.
here it is, this should be remain static, 84,000. Then you pay again 10 lakhs. 1 lakh, na?
1 lakh.
1 lakh. But here you have how much? 6 lakhs 50,000 remaining. From there only it will come down to 5 lakhs 50,000. We are not touching this, na? There the calculation you are making mistake. This has to be static. Principal, and you don't touch the principal unless and until there is appropriation from the interest and the cost. So here the mistake happens at on 8/2/2016, the date which we have given.
8, 12, 2006.
So here, therefore, if you see Mr. Khatonia's thing, 7 lakh 50,000, you pay 10 lakhs, and therefore on the right hand side you have 6 lakh 50,000 remaining. Then again you pay another 10 lakhs, 5 lakh 50,000. Again here there is an accumulation of the interest. So this interest keeps on accumulating. Because there cannot be an interest on interest. Interest is always on the principal.
Lots.
So these are the interests which are accruing, and these are just getting added out here. And thereby it is adding, you see. So here it comes to 32 lakhs and the other one comes to 7 lakhs. From 1 to 4 you have done it properly. Then the mistake happens.
No.
From 8. You cannot touch the principal
Because the
unless you first.
entire amount, the interest and the principal, they took together and made the principal as 14 lakhs.
No, you cannot touch the principal. Here what you have, the mistake is, you have brought this 6 lakh 50,000 here.
With the principal.
You can't touch that. This you have to remain as static, 8 lakh 40,000, which will remain till you don't extinguish the interest. And from that interest it gives on. So the mistake happens from here.
Okay.
8/12/2006, the mistake happened.
8, I have.
So when you are going to correct things,
But I would like to pray that one copy that they have prepared. I request for a copy of that. And I'll send it to them, they will reconcile and compare.
when are you coming back?
But let it be on Tuesday.
Don't delay it. You are paying interest at 18%.
That's the thing, interest is accruing. Let it be on Tuesday, next Tuesday,
Next Tuesday,
next.
both the parties have placed before this court the calculation sheets. The calculation sheets submitted by Mr. Hey, step let me do. By Mr. Dina, the learned senior government advocate, as well as the standing counsel of the PWD, is collectively is kept on record and marked with the letters A and B. Mr. P.K. Khatuniya, the legal counsel appearing on behalf of the respondent, have also placed the calculation sheets in respect to both the matters. The same are kept on record and marked with the letter X and Y. This court, upon perusal of the calculation sheets so provided by the petitioner, as well as the calculation sheets which have been provided by the respondent, is of the opinion that in terms with the judgment of the Supreme Constitution Bench of the Supreme Court in the case of Gurpreet Singh versus Union of India, reported in 2000.
2006.
With the judgment, yeah,
6, 8 SSC 457.
so and so. The statements so provided, the calculations so provided by the respondent seems to be more accurate. Be that as it may, this court gives an opportunity, further opportunity to the Mr. Peanut to make further verification on the basis of the calculation sheet so provided and kept on record and marked with the letter X and Y. Was taking into account that the interest is accruing at the rate of 18%, this court is of the opinion that the matter requires an early culmination. Let's list this matter again on 18th of March 2025 for further hearing at 2 p.m. You've heard it. See, what we propose, once it comes out on 18th, then there are two options available. Either this court has to say that this is the amount you are liable, and the executing court shall issue a precept for that. But this would further delay the proceeding and it will again, or you have to give an undertaking before this court that we are going to pay within this. And I think Mr. Attorney, if they give an undertaking by way of an affidavit, this, the interest has to be curtailed out, means not curtailed, it has to stop from that undertaking. I think then we need to end the matter. Otherwise, it is going to create a. After all, we also have to think about the state. What do you mean?
Item 20 to 25.
But Mr. Nath, therefore, you need to take it seriously. And I won't be here from 1st of April, so therefore, you need to do it. And Mr. Nath, you come this side also for these matters. This side. When was the award passed?
Not this 38 may be seen though. See payment.
Paid?
38. I have received the payment lordship on 7/1/2016.
7?
1/2016.
And when did you file it?
This 18 may be seen lordship.
31/2016.
In all the cases, lordship, we have annexed the payment voucher. Lordship.
And why was it dismissed? Let us see the order.
Yes, 26.
Whether the suit is maintainable, whether the defendant has not assessed, whether the relief. What is this? 18.
Yes, 29, lordship, paragraph 10 may be seen.
Submitted. Why limitation barred? Where's the finding? Why it has been said it to be barred?
Yes, lordship. 20, page 35, paragraph 20.
55. Why? No, why is it barred?
Also, because it is barred, that's mentioned in paragraph 10, page 29 of the implement order, lordship. The learned court will reckon the delay, lordship, from the date of declaration of the award.
The
Paragraph
issue
10.
relates with the maintainability from a year it is revealed that the award was declared in 2007.
And in the instant case was filed on 2016. Accordingly,
2007.
count
However,
from
the
the
instant
9 years
petition was
period.
filed on the month that is after lapse. Further, a petition under combination was also filed. Stated that the branch of Illinois has informed the petitioner in the year 2014 for receiving the awarded amount and accordingly had signed in the payment voucher. Further, they stated that they could not meet the advocate for consultation. You stated in 2014 you met the lawyer.
While filing the, though the petition was in right time, they have filed the reference petition.
Ah.
Wrongly filed a condonation petition. along with-
It's okay,
And in
condonation,
the condonation petition.
we,
it is
let us
stated
not go by the condonation.
Yes,
But
in-
when did you receive the notice?
that so far our statement in reference case, did not receive the notice.
Ah.
We have not received the notices. Payment, So far the payment is concerned, Lordship, section 12 of the Land Acquisition Act, Lordship. Payment content, notice containing the payment, Lordship, should be notified to the landowners.
When was it issued? But what is this being mentioned that you have stated that the branch of LA Dhubri has informed the petitioners in the year 2014?
Lordship, it's wrongly, Lordship, mentioned in the condemnation petition, Lordship. I am coming to the, Lordship, kindly see the condemnation petition, page 21. If the condemnation petition was filed along with the reference case, Lordship, in para 2, page 22. Lordship,
20?
Page 22, para 2. This is the wrong statement made, Lordship. Paragraph 2, on the same petition, Lordship, in para 5, Lordship, this is also mentioned. Contradictory statement, Lordship. Yeah, next the payment voucher where it is mentioned that Lordship, we have received the payment in the year 2016. But the condemnation petition
It
is
is not
only
the question of payment. It is the question of when did you know about the 12-2? When was the notice of 12-2 given?
that is not
12-2
Complicated.
notice when given? Did you produce that? Exhibit 12-2 notice.
12 to notice, but the evidence has been discussed at page 31. Kindly see how the learned court has appreciated the evidence.
Yes.
My lord, page 31, paragraph 12. In the instances, the petitioner filed under section 5 of the limit, whereby it is stated that the petitioners are illiterate persons. However, this court can observe that the petitioners put their signature in English and Assamese, which goes to show that the petitioners are not illiterate persons. Further, illiteracy or poverty cannot be a ground for condemnation of delay. Now, this is important. Further, upon perusal of cross-examination of one of the petitioners, namely Muhammad Ali, who appeared as PW1, goes to show that he has admitted that he was present during survey, which was conducted at the time of acquisition of land. He also admitted that he was notified after acquisition. Further, he also admitted in the cross-examination that he received rupees so and so. He further admitted that the land was acquired in the year 2005-2006. It is also pertinent to mention here that Horatio Berman, PW3, who appeared on behalf of the office LA branch, has mentioned in his cross-examination that no written complaint was filed by the petitioner at the time of receiving the compensation amount.
Now that is on a different line. That is with protest or without protest, that is another aspect, which is another. But on the question of limitation,
Therefore, because my lord, in section 18 of the Act of 1894, there is no enabling provision. Thereby, my lord, giving a leeway to the person concerned, affected party, if there is a delay, my lord, he can under such circumstances also make a defiance before the defiance court. The periods are, my lord, 6 weeks, 6 weeks, 6 months. 6 weeks, 6 weeks, and 6 months. How it is, my lord, provided? Kindly see, my lord, section 18. Section 18, my lord, subsection 2. The application shall state the grounds on which the objection to the award is taken. Now, proviso is important, provided that every such application shall be made. A, if the person making it was present or represented before the collector at the time when he made his award within 6 weeks from the date of the collector's award. That is first part. Then in other cases, within 6 weeks of the receipt of notice from the collector under section 12. Then, my lord, subsection 2, or within 6 months from the date of collector's award, whichever period shall first expire. So even if, my lord, that he has not received any notice, then also, my lord, he has a, my lord, breathing space to the maximum limit of, my lord.
that has been so cleared by Supreme Court. There's no worry with that. You see the judgment of the Supreme Court in
Yes,
this
yes,
regard,
Yes,
in the case of, I think,
that time,
his judgment, Bhagwan Das.
Yes.
Bhagwan Das, Supreme Court categorically says 3 things. How the EI has to be given. categorically says that the following emerges that if an award is made in the presence of the person interested or his authorized representative, he has to make the application within 6 weeks from the date of the collector's award. If the award is not made in the presence of the person interested or his authorized representative, he has to make the application seeking reference within 6 weeks of the receipt of the notice from the collector. If the person is interested or his representative was not present when the award is made, and if he did not receive the notice under section 12(2) of the collector, he has to make the application within 6 months of the date on which he actually or constructively came to know about the contents of the award. This is the law. So here in this case, the question was before the Supreme Court as to whether it will be deemed from the date of the note on which the award is passed and filed in terms of section 12, or it would be deemed when he has active or constructive notice about this thing. So Supreme Court says it cannot be on the date on which 6 months cannot be counted from that date. It has to be counted only when he has active and constructive notice.
That is, there is no denial. Now here, my lord, we have now payment when received. Even if I present for the time being, that no notice was received. It is the admitted position that award was first. He is not after the award. He is after the quantum. Award was first. It was in accordance with law. And my lord, these part and parcels of land were acquired under the emergency clause of section 17. These are all admitted facts. Now, therefore, my lord, the date when he received payment would be of my lord patent.
He received on 7/1/2016.
7/1/2016, therefore.
So that should have been taken into consideration by that court.
Yes, 7/1/2016.
And he filed it on 31/2016.
Yes, no, they have filed it on 28/1/2016 before the collector. Therefore, before the collector, 28/1.
28, no, 31.
So from here, my lord, page 21 of the requisition goes to show, my lord, page 21. Because they have.
This 18. Annex one.
This is on page 18. I'm into LA 7.
Yes,
It is a 4th of February 2016 stamp.
yes, my lord, 4th of February. But here, my lord, it is stated, my lord, that signed, my lord, signing date on the right hand side, my lord, it is 31/2016. That appears at page 18. This is the application before the collector. Another application, my lord, for condonation of delay, that is at page 21. There, my lord, they have stated it to be on 28/1. It is 2 days ahead.
That is immaterial.
Nonetheless,
But the
nonetheless.
fact that, you see, the Supreme Court in this judgment say, you see, one may also know that there is an award,
Yes, absolutely.
but how will he know that the award which is there, what is the contents of the award?
There is a statutory duty casted on us. We have to inform.
So therefore, it is the duty under 12(2) to inform,
Absolutely.
which have not been informed.
That, my lord,
Now, the second issue is whether revenue is made a party or not, it is for that court, for the collector to do so as well as the court to do so. How can it be said that it is not maintainable? He is only going to ask, then look here, this is the amount. You see, in respect to filing a objection under section 18, there are 4 aspects. First, as regards the quantum. Second, as regards apportionment. Third, as regards the entitlement, and fourth is as regards the measurement. These are the 4 aspects. Now the Supreme Court says that if you file on quantum and later on you cannot amend on apportionment because the period of limitation goes
yes,
away,
yes.
so you cannot do so. So the law is clear on that aspect. Now there is a judgment of Justice Sama where it says you can't incorporate section 5. But there's again a later judgment when it says you can incorporate section 5.
What does is, my lord, I think.
But
it's-
Bhagwan Das makes
does
it
I
very
think
clear that irrespective of all these things, irrespective of everything, these are the following parameters from which the period will be taken. Now, just for example, Bhagwan Das goes ahead to say that in a case that after 6 weeks, he receives the section 12 notice.
There may be a situation.
6 weeks is how much? It's 36, 42 days. He receives a section 12 notice. Then from section 12 notice, again another 6 weeks,
Definitely. Yes,
not 6 months.
yes, 6 months.
It
Because
is,
That
that is
the
what has been
statutory
stated by
requirement. Yes,
Bhagwan.
yes, yes. That is the reason again.
Now the question is, that is one aspect on the question of limitation,
Yes.
which the learned trial court did not, reference court did not address properly.
Yes, I have to admit it.
Why I am taking up this matter at the threshold, taking into account that if I am to remand it, it's okay. I'll remand it so that unnecessary, there is no question of further accruing of interest if there is an increase. Because if I keep this matter pending, it will go for ages.
Yeah, absolutely.
And at the end of the day, when I transfer it to them, it becomes clear.
Because the interest accumulate.
Now, the second issue on which it has been dismissed is the revenue. The question is, how does the revenue come into the scene? The collector gives them over. Land was taken for whom?
Land was taken, my lord, it was for the construction of, my lord,
Land was taken also for the construction of composite check gate at Sagolia.
What?
yes,
Computer?
composite check gate.
Composite check gate.
Segget.
And
Well,
it's
that
Sagolia
must
located.
something, some beneficiary, some other department. Revenue has no business out there. Revenue may only issue section 4, section 6. This is approval as well as the declaration will be made by the revenue. But it is done at the through the agent, that is the collector. So who are the necessary parties out there would be, and it, as per section 20, it is the duty of the reference court to make them a party, whoever it is. You cannot,
No,
any,
no,
without
has
these
power,
type of
yes.
things, issuing.
Has the power, yes. Court has the power.
I think it is high time, Mr. Bhattacharya, you should go to the reference court, explain the scope. His
Yeah.
only duty is to see as to whether the quantum is right or wrong. It is for the state to prove that the true market value of the land, it is the duty of the state to prove. If he wants, if the state fails to prove, he can very well prove something.
Yes.
But the duty is, because it is an offer after.
Absolutely. And since, well, section 18 is a beneficial provision.
In
I am
fact,
arguing-
Bhagwan Das refers to a beautiful judgment of 1963, wherein it gives a very good understanding why it should not be from any other date but from constructive and actual notice.
Definitely, because the element of knowledge will assume have no significance. There may be a degree which may be passed behind my back. So from the date of my knowledge, there may be a cell in behind my back. So from the date of knowledge. So it is also inculcated in the Limitation Act also,
How can you dismiss? This is for DM, State of Assam is a proper party. How can you dismiss? See paragraph 19,
Yes, 99 is serious matter.
barred by limitation and not making somebody a party.
Perhaps the reference code down below misconstrued.
And he's more,
To be the requiring party.
he is more concerned about Salman on jurisprudence instead of knowing the fundamentals of land acquisition.
Because why I am partial, because the very basic element, for dismissing, but the date of knowledge is considered rightly followed from lordship, The date of knowledge is not explicit in the judgment.
There.
Either-
You may say, okay, 2024, 14, they may say so, because they have stated on affidavit that some person has informed us about 2014. But where is the notice? You may very well prove that a notice has been issued, he has received it, and as such, he has come later.
No pending whatsoever.
Nothing.
And even if, therefore, my lord, even if I presume for a moment that there was no notice in that, then also, my lord, his date of receipt of payment. Because one way or the other, he has to have the knowledge. He has to
He
have the
has
knowledge.
to have the knowledge
Yes, yes.
about this. So, and a second ground is furthermore atrocious.
Super plus. I will not comment on it.
We do one thing, allow all the appeals, remand it back, and then let them decide within 6 months. Because you see, if it is more or whatever maybe, it has to be done as quickly as
No, no,
possible.
no, I take it, I take it.
Because if it is not done,
Yes.
his interest is
Hey,
very
evidently, my
dangerous.
lord, it is, my lord, the excessive
Like I was
jurisdiction
taking
is-
his case, the PWD. This is a phenomenal interest, 18%. Please, an appeal should have been filed.
You also this is one thing, this matters may not back to the learned inference code. That's the parameters, indicate the parameters, because these are palpably my lord, seen out.
Okay, let me dictate in your presence. So you just correct me if I'm wrong. এটা মই দিম, বাকি কিটা একে টাইপে হ'ব। খালি ডেট কিটা একেটাৰ পৰা ল'ব, আৰু ডেট যদি নিদিয়ে সেইকেইটা ডিসমিস কৰিব। Heard Mr. So and so, the learned counsel appearing on behalf of the appellant. And Mr. Arbor Pujari appears on behalf of the Revenue Department of the Government of Assam, as well as Mr. Deputy Commissioner, Mr. Nath, Mr. D. Nath appears on behalf of the learned senior government advocate appears on behalf of the Deputy Commissioner. On behalf of the Deputy Commissioner, District Collector, District Commissioner, like District Collector. That is the response number 2. The instant appeal was filed, is filed challenging an order dated, challenging an order of the reference court dated there's a delay condonation. Mr. Counsel, is there a delay condonation?
Yes, my lord, page 21 is the delay condonation petition. And page 8 is
No. Here you have approach. 25 August 2023. Why it has been filed such a long time? There was a defect?
Yes, there is a delay out here also.
No. 11/1/2024. You see? It has come after 1 year. You see, Mr. Counsel,
No.
you shall not be entitled to any interest for the period from the date of filing, if there is an enhancement from the date of filing till today. Do you know the reason why? You filed it without the wakalatnama, signing the wakalatnama. No interest. And I may put it in the order that that interest which you may would have got it, your client may recover it from you. Why didn't you put your signature in the wakalatnama? That is the defect. You don't know. How many years of practice you have? How many years? 18 years. Are you not aware that in a wakalatnama you have to sign? Huh? You don't know.
But Lordship, sometimes Lordship,
Sometimes
Lordship clerks without, sometimes in hurry, Lordship, they have filed without taking my signature. They have to
Yes.
rectify.
no interest for this period. This is an appeal filed under Section 50 of the Land Acquisition Act 1894, challenging the judgment and order dated 25/8/2023, passed by the Court of the Learned Additional District Judge, Dhubri, bracket the Learned Reference Court, whereby the reference proceedings being LA case number 102/2017, which arises out of LA case number 1/2005-06, was dismissed primarily on two grounds. That is, that the reference proceeding was barred by limitation, and further on the ground that the respondent number one, which is the Revenue and Disaster Management Department of the state of Assam, was not made a party. Taking into account that on these preliminary grounds, the reference proceedings have been dismissed. This court have taken up this appeal at the stage of admission. It's appeal for dismission, for disposal at the stage of admission with the consent of both the parties. This court have heard the learned counsel appearing on behalf of the appellant, who submitted that the appellant herein received the amount of compensation on 7/1/2016, and immediately thereafter, on 30/1/2016, the reference application was filed before the district commission, the deputy commissioner of the district collector. He submitted that this very aspect of the matter was not taken into consideration. The learning counsel for the appellant further submitted that in terms with section 20 of the Land Acquisition Act, 20 of the Land Acquisition Act 1894, for short, the Act of 1894, it is the duty of the reference court to make it is the duty of the reference court to make parties and not dismiss a reference proceedings on the ground that some party have not been arraigned. The learned counsel appearing on behalf of the appellant further submitted that as per the statutory principle of law, the collector as well as the beneficiary of the acquisition proceedings are required to be made parties. It is judgment as a magnite. What is that judgment's name? Magnite, lignite or something. The 95.
Yes,
3
I
SEC.
will check it.
In that regard, he made the reference to two judgments in that regard, he mentioned. Mr. Arbo Pujari, the learned counsel appearing on behalf of the Revenue Department, submitted with all fairness that the Revenue and Disaster Management Department's role in an acquisition proceedings is limited to the issuance of the declaration under Section 4 and the issuance of the notification under Section 4, declaration, granting the approval for the declaration under Section 6, as well as for granting approval to the award when placed before the Revenue Department. Under such circumstances, as the money, as the instant reference proceedings is only limited to the question of inadequacy of the compensation. It is the collector who has to be made a party in terms with Section 20 of the Act of 1894. And in view of the judgment of the Supreme Court in the case of so and so, it is the beneficiary who has to be made up arrayed as party by the reference court. Mr. Dina, the learned counsel appearing on behalf of the district collector, has submitted that What is your submission? Don't say that I don't.
The amount was awarded amount they received in the year 2016. They are saying that from the date of the knowledge, they have come. That
The learned counsel appearing on behalf of the Mr. Dean at the learned counsel submitted that though the impugned judgment and impugned order, the judgment and order appears to be lacking in the question of due application of law. But he pointed out as regards the deficit, he pointed out as regards the conduct of the appellant, in as much as the appeal was filed as far back as on 18/1/2024, and there were defects which remained, which were not rectified for were not rectified. And it is under such circumstances, the instant appeal is being taken up. It has been first listed before this court. Oh, no, it's okay. That also no. This is the mistake of the registry. As agreed by the learned counsel for both the parties, leaves the matter on 7/3 and thereafter matter did not come. Mr. Dina, the learned counsel appearing on senior government advocate submitted that from a perusal of paragraph number 12 of the judgment, it would be seen that the appellant herein have admitted that the land was acquired in the year 2005 and 6. And as such, he ought to have been more diligent enough. And as he had to be diligent enough. For which the impugned judgment and award have been rightly passed, dismissing the LA reference proceedings. This court, upon hearing the learned counsel appearing on behalf of both the parties, frames 2 points for determination. First, number one, whether the reference proceedings were time barred, were barred by limitation in terms of section 18(2) of the Act of 1894, number one. Number two, whether the reference proceedings could have been dismissed on the ground of not arraying the Revenue and the Disaster Management Department of the Government of Assam as a party to the said reference proceedings. Let this court first take up the point for determination number one. For deciding the point for determination number one, this court finds it relevant to take note of section 18 of the Act of 1894. The said section is quoted here in below, reproduced here in below. A perusal of the above section would show that any person interested who had not accepted the award may, by written application to the collector, require the matter be referred to the collector. May require that the matter be referred by the collector for determination of the court on the following aspects. That is, objection to the measurement of the land, semicolon, the amount of compensation, semicolon, the person to whom it is payable, semicolon, or the apportionment of the compensation amongst the person interested. It is further seen from a perusal of section 18.2 that for the period of limitation have been stipulated as to within what time the said application is required to be filed. In terms with clause A of section 18.2, it is stipulated that if the person making the application was present or represented before the collector at the time when the award was made, then within 6 weeks from the date of the collector's award. In terms with subclause B of section 18.2, it is 6 weeks of, it is the period of limitation is within 6 weeks of receipt of the notice from the collector under section 12(2) of the Act of 1894, or within 6 months from the date of the collector's award, whichever period shall expire first, later, na? First. First.
Whichever period shall first expire.
First, expire first. First. This court finds it relevant to take note of a judgment of the Supreme Court in this regard. Which clearly explains the scope and ambit of section 18.2 of the Act of 1894. Paragraph number 28. Paragraph number 24 to 28 of the said judgment being relevant is reproduced herein under. From the above quoted paragraph, the said judgment, नाम तो खोलूं ना? Judgment of the Supreme Court in the case of Bhagwan Das and others versus State of Uttar Pradesh and others, reported in 2010 3 SCC 545, where and paragraph number 24 to 28 of the said judgment is reproduced herein under. From a perusal of the above judgment, it would be seen that the Supreme Court had observed that if the award is made in the presence of the person interested or his authorized representative, the person interested has to make the application within 6 weeks from the date of the collector's award itself. In the case where the award is made in absence of the person interested or his authorized representative, the person interested has to make the application seeking reference within 6 weeks of receipt of the notice from the collector under section 18.2. The Supreme Court further observed that if the person interested or his authorized representative was not present when the award is made, was neither present when the award was made, nor was issued nor received any notice under section 18.2, 12.2 from the collector, the person interested has to make an application within 6 months of the date on which he actually or constructively comes to know about the contents of the award. This court further finds it relevant to take note of another paragraph of the said judgment, that is at paragraph number 31, wherein the Supreme Court duly explains as to how actual or constructive knowledge of the contents of the award can be established by the collector. This paragraph, being relevant, is reproduced here in below. The reason for reproducing the above paragraph, it is to show that it is for the collector to prove before the reference court that the person interested had received or drawn the compensation amount for the acquired land, or has attested the proceedings delivering possession of the acquired land in pursuance of the acquisition, or has filed a case challenging the award, or has acknowledged the making of the award in any document or in a statement on oath or evidence. It is seen, however, from the records that there is no such evidence in the record, evidence to that effect by the collector. There is also nothing which have been discussed in the impugned judgment as regards issuance of any notice under section 12(2) upon the appellant. What is seen from the above is the learned trial court merely on the basis, learned reference court merely on the basis that the appellant knew that there was an acquisition proceedings initiated in 2005 and 6. There's 6. Have held that the reference proceedings was barred by limitation. The reference proceeding in the court further did not take into consideration that it was only on 17-1. 17-1, when did you receive it? Only on 17-1, 7-1, 2016, when the petition appellant had received the compensation, and immediately thereafter, on 30-1, 2016, the reference application was filed. Considering the above, it is the opinion of this court that the learned reference court had erred in deciding the issue, deciding that the reference proceedings was barred by limitation. Rather, in the opinion of this court, the reference proceeding was filed within the period of limitation as prescribed under section 18(2) of the Act of 1894. In the backdrop of this, let this court now take up the second point for determination. It is seen that when a reference application is filed, when an objection is filed to the award under section 18, there's a duty cast upon the collector under section 19 to make a statement, to submit a statement. Submit a statement while making a reference for the information of the court. Wherein it is further very pertinent to mention that section 19B categorically mandates that the statement shall contain the names of the person whom the collector has reasons to think are interested in such land. It is further seen that in terms with section 20, a duty is cast of the Act of 1894, a duty is cast upon the reference court to cause a notice specifying the day on which the court would proceed to determine the objection and directing their appearance before the court on that day. The objections, such notice would be issued to the appellant, to the person interested who has preferred the objection under section 18, semicolon. The persons interested in the objections, except such if any of them as have consented without process to receive payment of the compensation awarded, and in the objection is in regard to the area of the land or the amount of the compensation, then the collector This court further takes note of the judgment of the Supreme Court in Newey Magnite Equitas, wherein the Supreme Court further mentions that the beneficiary of the acquisition proceedings are also have a right to participate in the reference proceedings. On the above all perspective, it is seen that the duties to whom notices to be issued and to make them parties to the reference proceedings is cast upon the reference court and not upon the appellant, upon the person interested who has filed the objection and at whose behest the reference proceedings have been proceedings have been initiated. On that ground also, this court is in addition, this court further takes note of that the revenue and disaster management of the Department of the Government of Assam had no role as regards the quantum of the compensation. The quantum of the compensation has to be decided on the evidence to be deduced by the collector as to why the market value which have been offered to the person interested is the true market value of the land. In that view of the matter, the second point of determination is decided in favor of the appellant. Considering the above, considering the above 2 points for determination, this court is of the opinion that the learned first appellate court have not decided the reference for which the collector had sought for a reference, have not decided the issue as to whether the quantum of compensation was inadequate. Considering the above, this court is of the opinion that the impugned judgment and order dated so and so is required to be interfered with. And further, that the matter be remanded back to the learned reference court for a decision afresh on the merits. Accordingly, the instant appeal stands allowed. Accordingly, the instant appeal stands disposed of with the following observations and directions. Number one, the judgment and order dated so and so, passed in so and so, dated so and so is set aside and quashed. Number two, the appeal, the appeal is the proceedings before the learned reference court is restored. In the reference proceedings, the instant appeal proceedings stands remanded. Now, this court further remands the reference proceedings back to the learned reference court for a decision on merits as regards the quantum of compensation, merits on the question of inadequacy of the quantum of compensation. And for that purpose, this court restores the reference proceedings to number LA case number 102/2017 to the file of the reference court. Number three. Anything more?
So far as the spectrum of basis of payment. Whether he is.
This court, however, observes that this court, how it is observed herein that this court had only this set aside the impugned judgment and order passed by the learned reference court on the grounds of limitation as well as on the ground of non-joinder of necessary party. It shall be open to the reference court while deciding the issue of inadequacy of compensation to adjudicate as to the amount, whether the amount so received by the petitioner, by the appellant, was under protest or not.
Nifty Lignite Corporation, 1995, 1 SCC 221.
Na?
Full bench decision. Full bench.
Nevle?
Nifty Lignite Corporation versus Special Tahsildar.
Yes, 1995.
1995, 1 SCC 221. I'm obliged.
The name is something like that. Executor dispose of it. That is the court of the additional district judge. Dubri? Dubri. This court directs an exercise of the powers under Order 41, Rule 26A for both the parties to appear before the learned reference court on 23rd of April 2025 for further proceedings of the reference.
I'm so obliged.
Pending
Otherwise,
item
it will
two.
against technique.
That's the same, that's.
Pending item two.
Your Lordship, I have handed over the copy of the order of this court of 11th of February 2025. The facts of the case are very similar. In your Lordship, you have given a liberty to file an application. So, Your Lordship, the same liberty will be given to file an application before the tribunal.
No,
And
in that manner, I'll give you a better way. You see, as regards interest on future prospects, I've seen there are 4 judgments passed by my coordinate benches, wherein they say that there should not be interest on future prospects. There's also one more judgment from Jammu and Kashmir High Court where also they say so. There should not be that as it may. In another recent judgment of Supreme Court delivered on 24th of November 2024 by Justice Sanjay Karol, he has given interest on future prospects, specifically only on interest on future prospects. On future prospects, that was a case where future prospects, there was nothing given on pain and suffering and future prospects. Supreme Court gave on these 2 heads. Other heads are there, but in these 2 heads also they gave interest on future. This is the judgment in the case of A.S. Muralidhar versus R. Shivalakshmi and another. Civil appeal arising out of science. Here specifically it says, it stands clarified that we have modified the award so given by the High Court only on 2 counts, that is future prospects and pain and sufferings. The amount as enhanced shall carry interest at a rate of 6% from the date of filing of the petition for special leave to appeal. P1. I'm always against, because first of all, the reason which have been given by the court benches that this amount will accrue in future, and as such, there is no requirement of giving an interest. First of all, you have to understand why future prospect is given. This future prospect is given is that if this person concerned would have been all along in service, he would have got this. So under such circumstances, and it has been now, the coordinate bench decided that we are fixing the quantum today. So on future prospects, there is no interest.
What do you see? You could have back and again given the interest. The Pustak, which are Pustak of. All the
But what about fixing the rate of 50% or 20% or 30% on future prospects is being given? But on the rate, without taking into account that in future, there will be an enhancement on the value. Yes. Salary will could go up.
go up. Can have ordinary taxable part of the. All along, this.
It is only our High Court who have given in one age of Jammu and Kashmir.
One, yes,
And Jammu and Kashmir follows our High Court.
one yes, one more from the Kerala High Court, but they have taken a different view on it.
What do they say?
That taking the decision of only happened. One injury case was there, madam. In that case, one of the future prospect was interest on future prospect was given back. We're taking that into consideration.
Because I have all along given, that I am not going into that decision because I will have to defer with the other parties. But in my opinion, no. To insist on that, I would not mind to defer.
Lordship may, as
Because there is one judgment of Justice Surana, Justice Malashri, there is one judgment of Justice
Michael.
and he gives reason. Other two cases, they don't give that.
One is by Justice education law.
Future perspective no done. They have followed it. I don't have the intention of following it.
And that since the interest was 6% on since the awarded interest is 6%, and the lordship is only considering the point of our demand. The point that we.
No, I am not demanding. I'll pass the order in terms of the other judgment.
Yes, my lord, that also copy we have provided.
No, not these judgments.
This one, my lord.
Not these judgment. There's another one. No, not this one. Hey, we are Manus big on the top of the. No, no, no. I will have judgments. Thank you.
Is it not?
See,
my lord,
in
MSA
this case, there is another one, Oriental Insurance Company Limited. Now, what has happened here? My observations here I've given. Here, the court did not decide on the question of there was violation of the permit conditions. In this case, this particular person, there were 9 persons in that car. And of these 9 persons, they could not have taken in that. Secondly, there was also the issue as regards mentioned that in the report that there were 10 persons who were inside the vehicle when the vehicle accident took place, though the permissible limit of occupants of the vehicle was only 7. And another aspect of the matter which the specifically urged in the written statement by the appealing insurance company that the vehicle was used for commercial purpose. The investigation report which has been exhibited as evidence also mentioned that the vehicle was used for hire purpose. Besides, the FIRs were filed by the father of the deceased, which has been duly exhibited, stated his son had taken on hire the vehicle. Then I say that relevant to observe that if there are more persons than the authorized capacity, there would further be a case where the owner of the vehicle was responsible for the accident. All these aspects were not at all discussed by the learned tribunal in the improved judgment and award passed in so and so, and mechanically settled the liability upon the appellant insurance company. As such, it is the opinion of this court that the improved judgment and award passed in so and so are required to be interfered with insofar as settling the liability upon the appellant insurance company. It is the opinion of this court that this matter aspect be decided by the learned tribunal afresh by giving due opportunity to the appellant insurance company as well as the owner of the vehicle bearing the registration number so and so. Be that as it may, the vehicle in question being Bolero was duly insured with the appellant insurance company, and there is no dispute pertaining to the entitlement of the claimant in the claim proceedings as well as the quantum of compensation. Under such, this court is of the opinion that the appellant insurer is required to satisfy. So I asked them to satisfy it and then said, this court, however, interfered with the directions passed by so and so, whereby the appellant insurance company was directed to pay the said amounts so awarded in the claim proceeding, without considering the aspect as to whether the appellant insurance company was liable to pay the said amount or the owner was. Under such circumstances, this court directs the learned tribunal so and so to initiate proceedings in all the 4 MSC cases being so and so on applications being filed by the appellant insurance company as to whether the appellant insurance company will be liable to make payment of the awarded compensation, or the appellant insurance company can recover the said amount from the owner of the vehicle and take further consequences. I think this is the way one of these save yourself from order 41 rule 27 being dismissed by this. So let me therefore say that otherwise it is okay to, I won't touch it only on the ground of this. There was a written statement, no issues were framed in that regard. As such, let the on your application be decided, giving you an opportunity to accuse it.
Fine.
Once this is being done, your problem is solved.
Yes, that will suffice. Deposit the amount before tribunal.
Huh?
Deposit
Yes,
the-
and deposit and the tribunal will pass appropriate orders how it is to be
Fine.
approved. Chalo, let me dictate. The instant appeal is heard Mr. R.T. Batra, the learned counsel, appearing on behalf of so-and-so and assisted by Mr. So-and-so, appearing on behalf of the Colin, and Mr. S. Baker, the learned counsel, appearing on behalf. Now tell me whether service is complete.
Yes, Your Lordship, the respondent number 4, it's
One of
complete.
the expert.
Huh?
Before the tribunal, they are not complete.
Your Lordship, R4 has been duly served. R4 has not filed the wakalatnama, but service upon R5 has not been completed yet, Your Lordship. We have taken steps 3 eyes, but it has not been completed upon R5 driver.
But the liability will be the of the owner.
Owner, yes, Your
Owner
Lordship.
is complete.
Yes, Your Lordship.
It is seen from reports that the service upon the owner of the vehicle with the respondent number 4 is duly complete. However, none has here on behalf of the respondent number 4. So, taking into account the order, the judgment, taking into account the manner in which this court is proposing to dispose of the instant appeal, this court is of the opinion that the service upon the respondent number 4, though not complete, and this court dispenses with the service in so far as the respondent number 5 is concerned. This is an appeal under section 173 of the Motor Vehicles Act, challenging the judgment and award dated 21/8/2021, passed in MAC bracket death case number 37/2015, passed by the Member Motor Accidents Claims Tribunal, Morigaon, whereby an amount of rupees 34,07,000 was awarded in favor of the claimant along with interest at a rate of 6% per annum from the date of filing of the claim petition, that is 18/8/2015, till actual payment by the appellant insurance company. This court finds it relevant to take note of that for deciding the counsel appearing on behalf of the appellant has submitted that the sole ground of objection, that although various grounds of objection have been taken in the instant appeal, but the appellant insurance company would limit its submission only to the ground of objection that in spite of pleading, making a specific pleading that the driver in question did not have a valid driving license. The learned tribunal did not frame an issue in that respect and have mechanically settled the entire liability upon the appellant insurance company. So, taking into account the above ground of objection taken, this court finds it relevant to take note of the brief facts which led to the filing of the instant appeal. One, Pradeep Kumar Bista, bracket Chetri, along with one Samuel Enki, were traveling on foot towards Hamaran side and when they reached Umdhap along Juvi PWD road, a vehicle bearing registration number AS250358 bracket Tata truck coming from the backside and driven in a rash and negligent manner knocked down Pradeep Kumar Bista and his friend from the backside. As a result of the accident, Pradeep Kumar Bista and his friend sustained serious injuries. Both the persons were admitted in Hamden Civil Hospital. After preliminary treatment, Pradeep Kumar Bista was referred to the Guwahati Medical College Hospital. He was thereupon admitted in the said Guwahati Medical College Hospital. During his treatment, the said Pradeep Kumar Bista succumbed to his injuries on 24/3/2014. It is under such circumstances, the claim proceedings being MSC case number 37, MSC death case number 37 of 2015 was filed by the claimants who are the legal representatives or who are the legal representatives of Pradeep Kumar Bista. It is relevant to take note of that on the basis of the said accident, a Hamran police station case, an FIR was filed before the Hamran police station, and a case was registered being Hamran PS case number 6 of 2015 under section 279 oblique 338 oblique 304A of the Indian Penal Code. The claim proceedings upon being filed and registered. Notices were issued upon the owner of the vehicle, the appellant insurance company, as well as the driver of the vehicle in question. Neither the owner of the vehicle nor the driver of the vehicle participated in the said proceedings. The appellant insurance company appeared and filed a written statement wherein they had denied the various statements made in the said claim proceedings. In the said written statement so filed by the appellant insurance company, it was specifically pleaded that there was violation of the terms and conditions of the policy, as the driver did not have a valid and effective driving license. It was also mentioned in the said written statement that the amount of compensation claimed by the claimants were highly exaggerated and without any basis. On the basis of the said pleadings, as many as 3 issues were framed. The 3 issues are reproduced herein under. On behalf of the claimant, 3 witnesses were adduced and they proved various documents. The appellant insurance company, however, did not produce any evidence. On the issue as to whether, on the first and the next, the limit first appellate, the limit tribunal by the award dated 21st of August 2021, awarded an amount of rupees 34,07,000, along with interest at the rate of 6% per annum from the date of filing of the claim petition, that is 18/8/2015, till actual payment. It is relevant to take note of that while deciding the issue number 1, the learned tribunal came to a issue number 1 and 2, the learned tribunal came to a specific finding that the vehicle in question bearing registration number AS250358 was driven in a rash and negligent manner, and on account of and late Pradeep Kumar Bistar expired in the said accident due to the rash and negligent driving of the vehicle, of the driver of the vehicle, offending vehicle. On the issue number 3, the learned tribunal came to an opinion that an amount of rupees 34,07,000 was the adequate and reasonable compensation in terms of Section 168 of the Motor Vehicles Act 1988, and also further awarded an interest at the rate of 6% from the date of filing of the claim petition. Be it as it may, the learned first appellate court, the learned tribunal, at paragraph number 23 of the said judgment, came to a categorical opinion that the vehicle in question was duly insured with the appellant insurance company, which was valid up to 16/12/2024. And had also arrived at a finding that the driver had a valid driving license. It is, however, not known on what basis the learned tribunal arrived at such a finding. The learned counsel appearing on behalf of the appellant has submitted that merely on the basis that the learned tribunal did not have any basis to arrive at the conclusion that the driver of the vehicle had a valid driving license. Taking into account the above, it is the opinion of the court that as there is no materials on record to show as to how the learned tribunal had arrived at the finding that the vehicle driver of the vehicle had a valid driving license. The said aspect is required to be adjudicated by the learned tribunal on the basis of the evidence, which is already on the basis of evidence, inasmuch as the said aspect has a far-reaching consequences as regards settling of the liability upon the appellant insurance company. Be that as it may, this court is of the opinion that taking into account that the vehicle in question was already insured with the appellant insurance company, which is duly admitted, the appellant insurance company is required to satisfy the said award inasmuch as there is no fault on the part of the respondent, the claimant. Inasmuch as the entitlement of the claimant in terms of the award have not been put to question. Apart from that, this court further, after taking into account the decision in respect to issue number 3, is also of the opinion that the learned tribunal were justified in awarding the said amount of rupees 34 lakhs and 7,000 along with interest at the rate of 6% from the date of filing of the claim petition. Accordingly, the instant appeal stands disposed of with the following observations and directions. The judgment and award dated passed in MSC case number so and so, whereby the claimants have been awarded an amount of rupees so and so, along with interest at the rate of 6% with effect from the date of filing of the claim petition, that is so and so, the pursuer is not interfered with. It is also seen that at the time of admission of the instant appeal, there was no direction for payment of any amount. Considering the above, this court directs the appellant insurance company to deposit the said amount of the awarded amount along with interest so awarded before the learned tribunal, that is the court of so and so, that is the learned so and so, within 6 weeks from the date of the instant judgment. This court however, number 2, this court, however, interferes with the direction passed by the learned tribunal, whereby the appellant insurance company was directed to pay the said amount so awarded without considering the aspect as to whether the appellant insurance company would be liable to pay the said amount, without considering the aspect as to whether, without properly considering the aspect as to whether the driver of the vehicle had a valid driving license. Inasmuch as without a valid driving license, the terms of the insurance cannot be. It amounts to violation of the terms of the insurance. Under such circumstances, this court directs the learned tribunal, that is the court of so and so, to initiate proceedings in so and so, in case too long to be done. On an application being filed by the appellant insurance company as to whether the appellant insurance company would be liable to make the payment of the awarded compensation, or the appellant insurance company can recover the said amount from the owner of the vehicle bearing, the owner of the truck bearing registration number so and so, and take further consequential steps. In that regard, this court observes that the learned tribunal shall afford due opportunity to adduce further evidence, if so, even further evidence to both the parties. Also, the statutory deposit of rupees 25,000, so deposited by the appellant insurance company at the time of filing of the appeal, be refunded by the registry of this court to the appellant insurance company upon the deposit of the remaining amount as directed herein above by the appellant insurance company before the learned tribunal, and thereupon producing the order from the learned tribunal evidencing the deposit made before the registry of this court. The The registry, this court is not inclined to impose any costs. Oh, 8. Report at a deposit to the toilet or piece of it. This court further directs the learned tribunal to release the said amount so deposited to the claimants by taking in the manner by keeping in the manner as stated in the impugned judge in paragraph number 25 and 26 of the impugned judgment and award dated 21/8/2020. What this?
Orders item 3.
Also, we'll have a look at the page, the order passed by your lordship earlier on 29/4/2024.
29/4/2000. I am the only one who passes these long orders.
The lordship wanted the
Even prior to completion of 5 months, an application was filed with the under section of this program. Now, what has happened, Stephen?
only, my lord, two PWs, my lord, so two PW.
Long after such a long time.
Yes, my lord. And I am ready, as I said, your lordship has similar order, my lord, on any condition. Whether I may dismantle the construction or hand it over, or my lord, no third party right, lordship. similar pass similar order. So, my lord, half constructed, 80% is constructed, my lord, I am, my materials are waste, so I will pass this order, my lord. Lord, we have to look at this, though, my lord, ultimately, here, the petitioner did not, reach the condition, but then the lordship put that condition. Any conditions will have it. Only, my lord, when the suit was, only PW2 was over. There are official witnesses also.
Read the plaintiff.
Plaintiff, my lord, felt is the
What are you challenging here?
Here, my lord, here, after the Supreme Court has granted me a liberty, my lord, because initially an injunction was refused to them. An injunction appeal was filed. And this honorable court said you dispose of the suit within 5 months' time. And giving definite time, my lord, to the
That
plaintiff.
is impossible.
Then we approached the Supreme Court. And Supreme Court passed an order, said since time frame is given, we are not interfering, but if you feel that it is not completed, file an application before the trial court. I filed it, and that is rejected. Against that I filed. And so, for my lordship, now my lordship has given similar orders for all conditions. I am ready to lordship put any condition to me. Yeah, the petitioner also did not.
No,
What-
not this one. Take the other order.
Uh,
This is another one, Mr. Samuel.
Yes, sir.
He appeared in that matter. Take his order. You do one thing.
Lordship.
You file an affidavit.
My lord, affidavit.
You file an affidavit to that effect. On the basis of the affidavit, I will
Right. That's
dispose. We dispose of the waste. This type of matter should not.
Lord.
We will give an undertaking that in the circumstance, the building is completed by him. And if it is between in your favor, he would have no objection in giving it to you without seeking any further decree. Or that he would not create any third party rights in respect to the building.
I'll give it.
Should be happy.
Any purpose of finding that suit will be factual. This is considered very good. Right? Yes. If
No. First of all,
first
why is it taking such a long time? It was a suit. Mr. Roy, that day I passed a judgment, a very important judgment, which may have an impact on the entire civil proceedings. I say, there is no question of fixing a date for filing evidence examination on chief. The concept is totally foreign. Earlier, we used to file application, we used to have the chief being recorded, then the cross immediately.
Oh.
Or the next, if you see the provision of Order 17, Rule 2A, the proviso A, that every day it has to go on the next day. That day it has to be done or the following day. And if on the following day it is not done, then he has to express great reasons as to why it is. So I say, so under no circumstances, why an examination in chief cannot be said to be an evidence is reason that the legislature never said that this to be evidence. They put the word evidence in Order 40, Order 18, Rule 4.2 and puts it evidence, then puts it within the bracket of cross-examination and re-examination. To mean it would become evidence if it is subject to cross-examination and
Exactly.
re-examination. So under such circumstances, further I dealt with Order 18, Rule 2 and say that what is required for the learned trial court to look into is to fix a date for hearing of the suit. Once the hearing of the suit starts, it encompasses within itself adducing of evidence, stating your case, other person adduces evidence, oral arguments, written arguments, all are included within the fold of hearing of the suit.
Okay.
And in total, you are entitled to only 3 adjournments maximum, that too for sufficient reasons. Otherwise, no. Beyond that, not permissible except if heavens fall.
I think it's good.
Because otherwise, people are going to lose
Yes.
faith in civil litigation. One has to be strict on this. And if you are not strict, we cannot be. That day I saw a very beautiful judgment on by, this is Ravindran. A very beautiful judgment. Wherein he says that, yes, as regards limitation and all he was saying that the law may be harsh, but that is law. You have to comply with it. It is only in exceptional circumstances you cannot. So it has to be. I am surprised why, when I passed the order on 29/4/2024, almost 1 year has gone and it has not finished off. It is not done. We fix it on the. You have failed. We do one thing. We call for the records and strike off your evidence. No more evidence of yours. That will be better. And then without evidence, the plaintiff suit should be dismissed. Matter over. Simple.
Told only PW first, PW is start. So there are official witness also of the PW.
This can't happen. EW and official witness, all these things has to be complete. I think it is high time that there is another judgment I have referred to of Justice M.R. Shah also in that case, that people are losing faith in civil religion. The reason is why he has categorically mentioned that if such a time as such adjournments are being given, it may be one thing that I may be, if I keep on giving adjournments to you or everybody, I may be very popular amongst the advocates, but that cannot be for the administration of justice. Anyways, I am thinking otherwise. I shall be granting adjournments everybody. Then only the things I'm going off from first. I'm coming back after 14 days. Thereafter, I'm thinking that I will take up the matter where the current lawyers want it to be taken. The reason is there are many lawyers who want their matter to be done. Why should I spend unnecessary time? There are people who are waiting. Getting a matter listed before the court is a very big thing. When I was practicing, this is the biggest problem. So that is why I make it a point that I used to take up these matters whenever it is needed. Because getting a matter listed in a court is very difficult. Anyways, the issue involved in the instant proceedings, as duly recorded by this court in its order dated 29/4/2024, is whether the petitioner should be permitted to go ahead with the remaining 20% of the construction. It is relevant to take note of that the coordinate bench of this court had directed that the suit be disposed of within a period of 5 months. Against that, an appeal was prepared by the petitioner herein before the Supreme Court. And the Supreme Court did not interfere, taking into account that the suit was directed to be disposed of within a period of 5 months. However, liberty was given to the petitioner to file application before the learned trial court if the suit can't be disposed of within a period of 5 months. On the basis of the said liberty, the petitioner had filed an application which was rejected, which is the subject matter of the present proceedings. It is very pertinent to observe that this court, by an order dated 28/4/2024, which is almost a year back, called for a status report as regards what is the status of the evidence, what is the status of the suit. The status report was submitted much later, stating that it was still at the stage of the plaintiff evidence. Taking into account the above, taking into account that if the materials which have been gathered by the petitioner is allowed to be gone waste on account of the delay in disposal of the suit. This court inquired with counsels on behalf of both the parties. This court inquired with Mr. P.K. Roy, the learned senior counsel, with Mr. Chakraborty, the learned counsel, as to whether his client would be willing to give an undertaking before this court that in the circumstance the suit is decreed in favor of the plaintiff, he would have no objection in that the defendant, the petitioner herein would have no objection in handing over the constructed house to the defendant, to the plaintiff, without any further decree being sought in that regard. This court further inquired as to whether the appellant, the petitioner herein, would give an undertaking as to whether would be in a position to give an undertaking as to whether the petitioner would not create any third-party rights over the over the constructed premises during the pendency of the suit. On the other hand, this court had also inquired with the learned counsel appearing on behalf of the respondent, who is the plaintiff, at whose instance there is an injunction as to whether the plaintiffs could give an indemnity, would be ready to indemnify the respondent as regards the loss if the suit is dismissed. The counsel submits that they will take instructions in that regard. This matter again on 19th March 2023, 5 at 2 p.m. If the parties hearing are agreeable to give undertakings as inquired into, they are directed to bring on record their stand by filing the affidavit on or before 17th of March. File my affidavit. Because otherwise we have to impose cost upon him. He has to indemnify. We'll ask him to put a security from amount 25 lakhs. To put a security of 25 lakhs, in the circumstance he loses, you lose the case, you give it to him. You can't keep on stalling a matter. Something needs to be done. Otherwise, take his house. You win the case, take his house without any further. I'll rise.